95 have been allowed. Criminal Bill 266 and 50 have been dismissed. Okay, brother. Thank you.
Item number 16 of today's list.
16, yes.
16.
Yes.
Lordship, in this case, led by Mr. K. Chaudhary is out of station. It may be listed on 24th. It's a motion matter. There is some urgency, but he had to go out.
Okay.
24th.
On a request made on behalf of the petitioner. Canara Bank, who is appearing?
Ma'am Sharma, I have informed him.
On a request made on behalf of the petitioner. Matter is adjourned to be listed on 24th to 24/6. Okay.
Deeply obliged.
I beg to mention a listing in matter.
Motion manner. Motion.
Hello.
May it please your lordship, I beg to mention item number 29.
29.
29.
Yes, what is it?
Lordship, we seek to file an additional affidavit in this matter, my lord. With the consent of the other side, lordship may kindly be.
Okay, railways, you have informed railways.
Yes.
Okay. On a request made on behalf of the petitioner, matter is adjourned by 2 weeks to enable filing of additional affidavit.
My lord, 4 weeks may be granted in
2 weeks, the vacations will come.
much obliged.
Oh, okay, 4 weeks will come. 4 weeks.
May I please your lordship? Lordship, I beg to mention item 41 of the list.
Yes,
With the consent of the other side,
yes.
due to some personal difficulties of the engaged counsel, matter may adjourn for the.
For the petitioner.
Yes, sir.
Okay. Yes, Mr. Roy. Right. On a request made on behalf of the petitioner, matter is adjourned to be listed after the summer vacation. Yes, 41. Yes.
I beg to mention item number 60, Lord.
60.
Yes, Lord. Hearing matter, Lord. The senior counsel is out of sick. Can it be after vacation? Lord?
Because Saikia is out of station. On 19 matter, madam.
Yes, Lord.
Okay. Well, fix a date immediately after the vacation.
Yes, Lord.
A prayer for adjournment has been made on behalf of the petitioner. On the ground that the learned senior counsel is out of station. Para, considering that this writ petition is of the year 2019, while adjournment is granted, comma, the matter is directed to be listed for hearing on 17th of July. 17/7.
Lordship, item number 37, 38, and 39.
Yes.
Yesterday, the respondent authorities had circulated a adjournment slip, but the matter is that they submitted in court number 17 because a similar matter has been posted there. Only the assessment year is different. Item number 10. And my lord, they have already taken adjournment in that matter today.
You are for whom?
I am for the petitioner, my lord. But due to shortage of manpower, my lord, they are not able to come here. Too many taxation cases have been listed. I have been informed. Just
When do you want? After the vacation?
they are taking time for filing the affidavit and reply. They have already taken time in court number 17.
Okay. But have they informed you that they will also
He
take time?
was here, my lord. He just informed me that
Okay,
too many
okay,
cases have been listed there.
37, 38, 39.
To be tagged with, my lord,
Okay.
item number 10 of court 17.
On a request made on behalf of
B.
the
Sharma on behalf of the
who is there? Finance and taxation?
my lord, B. Gogoi.
On a request made on behalf of the respondent, matter is adjourned by 3 weeks to enable filing of affidavit in opposition. List along with
Item number 10 of court 17, my lord.
number.
1634 of 2023. Writ petition number
1634 of 2023. Okay. 3 weeks. This will be up till 40. 37, 38, 39, 40.
37, 38, 39, 40.
Yes.
37, my lord.
Yes.
37, 38, 39, 40.
Yes.
But interim is there, my lord.
There are interim order passed earlier to continue till the next date of listing.
Obliged, my lord.
Yes. Yes.
Wait, please, your daughter. Back to mention, I pay for listing of an interlocutory application for correction of cost title.
Correction of cost title. Okay.
Yeah.
When?
On Monday or Tuesday, your
Monday or Tuesday you can have
Yeah.
motion this. Yes.
Please, your lordship. I beg to mention item number 6 and 36, lordship.
6 and 36.
Now,
Yes.
Engaged counsel, Mr. B. Pukan has some medical emergency, lordship. Matter may be called after 2, lord.
Okay. 6 and
36, lordship.
have you informed the other side?
No, not adjournment, lordship. Matter may be called after 2.
At 2 o'clock.
Yes.
6 and 36. Yes, we'll have it at 2 o'clock.
Please, lordship.
Who's appearing in 36?
Mr. B. Fukan Lordship.
Okay, no, in the, for the other side.
Here.
36, okay, you be there, 6.
Six,
Also revenue, who's there for 6 and 36, okay. Monkuiba, 6 and 36, okay.
Lordship, in item number 6, we have not received the instructions, Lord.
We can adjourn 6 then?
Yes, Lord. 36 is the Assam Gramin Vikas.
You are there. Have you filed your affidavit?
Yes, I have already filed.
Okay, he wants at 2 o'clock. There's some difficulty. We'll have it at say 6, we are going to adjourn.
Lordship.
6, okay. Item number 6, huh?
There is an interim lodged.
Okay. On the prayer of 3, S. Roy, Learned State Council, matter is adjourned by 3 weeks to enable filing of affidavit in opposition. Ms. G. Hazarika, Learned Standing Council Revenue is present. Para, list after 3 weeks.
Lordship, the
Para?
notice be issued, here notice is not issued.
Then let it reach them.
Lordship, Lord.
Let it reach, will issue notice, will protect your interim order.
Obliged Lordship. May it please your Lordship, with the consent of the other side, I beg to mention item number 31. Your Lordship.
31,
Yes, your Lordship.
yes.
Similar matter is fixed after vacation, so this matter may also be tagged along with a similar matter, your Lordship.
What is the similar matter?
Your Lordship, it is WPC number 59 of 2021.
You have informed the other side?
Yes, your Lordship.
What is your name, madam?
M. Borua.
Ms. Ambura, Learned Counsel for the Learned Counsel appearing on behalf of the petitioner
32.
has submitted
I report.
that there is a similar WPC, has prayed for an adjournment and has also informed that WPC 59 of 2021 is similar. Para, list this case after the summer vacation along with WPC 59 of 2021.
Much of.
May I please, your Lordship? I beg to mention item number 32, your Lordship.
32 years.
32, here, your Lordship, what has happened, your Lordship? I am appearing for respondent number 3 and 4, your Lordship. Now, your Lordship, my learned friend, your Lordship, is also appearing on behalf of respondent number 3 and 4, engaged by another group, your Lordship. Now, they have filed an affidavit in
Engaged
opposition.
by another group means
There is a clash between two groups, your Lord.
3 and 4. Who are 3 and 4?
They are parties.
No, 3 and 4 are individuals or some
No, your Lord, the committee, your Lord.
committee.
Trust. Now, who will represent trust, your Lord?
I have mentioned in my affidavit everything, Lordship, because they are an unauthorized person has appeared, and on behalf of them, my learned friend is
Lordship,
appearing.
they have
That
filed,
is why.
they have filed an affidavit, your Lordship. Let me go through it, your Lordship.
Yes, I will.
If I find that they have misled us, your Lordship, then I will withdraw, your Lord.
Lordship, in
For
this
that,
case,
your Lordship, I will have to take.
a date may be fixed for appearance.
No,
of
we
both
have
the parties.
seen that the petitioner is fighting against the respondent. We have never seen respondent fighting against first case perhaps.
In fact, there is a conflict in between these two groups, your Lordship, who claims to represent the
What is the group name?
name, your Lordship.
Rashtrabhasa process to me.
Prasad.
Wardha, Lordship.
Rashtrabhasa Prasar Samiti.
Wardha.
My lord, I also need to reply to that affidavit filed by my learned friend, my lord.
Okay, let us not reflect all this in the order.
Lord.
We'll say we'll adjourn it.
Lord.
You sort it out.
Lord.
Uh,
It will come after vacation.
we'll just indicate something. Item number
32. 30.
heard 3 B.D. Goswami Learned Counsel for the petitioner. Also heard petitioner, full stop. However, both Miss M. Dev, Learned Counsel, as well as Sri S. Bhattakur, Learned Counsel, have submitted that they were instructed to appear on behalf of the respondents 3 and 4. Full stop. However, there is certain anomaly in the matter for which time has been thought to sort out the same. Para. In view of the above, list this case after the summer vacation.
Lord.
The date may be fixed.
Tell us,
But we have to file affidavit.
summer vacation, by which time pleadings may be exchanged.
Yes.
Pleadings will be exchanged. List on, we'll have it on 23rd of July.
Well,
We support petitioner case, your Lordship. This supports respondent number 7.
As per order of the charity commissioner.
My Lord, I appear in this case on behalf of respondent number 7. I also.
You are in between them.
Yes.
Don't stand in between. Conflicts.
I also need some time to file my affidavit.
Mr. Ganguly is the mediator, it seems.
No, Lordship,
Mani-
against him in the case.
Manifestation is.
It is an example of Mr. Trump. You are denying.
Respondent 7 is the person, my lord. The nonagenarian, my lord, 97-year-old.
It is not maintainable itself.
Okay, on 23rd.
Third.
It's on 23rd.
Not my lord.
Ganguly for R7.
7.
3A Ganguly is present for the respondent number 7.
Right.
Yes, next. Contempt, yes.
May I please your lordship? Lordship, due to some personal difficulties of engaged person, Mr. S. Akan, matter may adjourn for the lordship.
Why do you seek adjournment in a contempt matter? What is the order? 2012, 2024. Where is the order? Do you have the brief or not?
No, I don't have the file, lord. He has instructed me.
What is your name?
Mr. T. Hussain, lordship.
You're in the case, you're on record, do not have the brief. You should have the brief at least.
I know the brief, lordship.
Then what is the case about?
And in this contempt petition, there is a deliberate and willful violation of the
What was the
Order
order? What was the order?
order. Was lordship actually.
You said you know the brief, you know the facts. You don't have the brief, you don't know the facts. You are on
I
record. There's nothing to fear, you
in
just.
this case, lordship, the
Yes.
the petitioner minor son died due to
What was the direction of the court?
directive of the court was granting the amount of rupees 2 lakh, lordship.
Where is your representation? Have you filed any representation? For compliance,
Yes,
requesting for compliance.
Yes, sir.
Heard Sri T. Hussain, learned counsel for the petitioner, who by means of this petition has alleged willful and deliberate violation of the order dated so-and-so, passed in so-and-so. He has also drawn the attention of this court to the representation dated 8/1/2025 submitted to the respondent, by which request was made for compliance of the order in question, para. Let notice be issued, returnable by 6 weeks. Let steps be taken for service of notice upon the respondents by registered post with AD. Steps within 2 working days. Yes. Take steps.
Obliged, lordship.
Next time come with the brief. Don't come empty-handed. Yes, next.
May it
Yes.
please your lordship, on the last occasion, this honorable court had got instructions with respect to the status of the GST registration of.
Yes, Mr. Barua.
My lord, I am appearing on behalf of each Fishery, my lord. Our instructions are awaited in this matter.
We issue notice then.
Lordship.
Heard 3 SD learned counsel for the petitioner. The grievance of the petitioner is with regard to a proceeding initiated by the show cause notice in respect of the GST registration of the petitioner. Full stop, para. Let notice be issued, returnable by 6 weeks. 3H Barua, learned counsel. You're standing counsel or you appear on learned counsel appearing on instructions of 3 B. Chaudhary.
My lord.
Standing counsel, Finance Department accepts notice on behalf of respondent number 1, 2, 3, 4, 5, 5.
5 and 6, 7.
6 is police station.
5.
5 and 6, okay, so 4 till 4, huh? SS Roy, 5 and 6, extra copies by Monday.
Obliged, my lord.
Serve extra copies.
My lord.
Yes,
Much obliged.
yes, Mr. Ahmed.
Follow the lordship has called for
not received the instruction.
My lord, the
Notice
fact-
may be issued, Lord.
The fact is this, my lord, I file a application.
That we know. Now, what has happened now? Registered or not?
Nothing has been done, page 19, the lordship.
That we have seen. Have you got
Based
the?
to the direction will be given to deputy. Look into the matter and
No,
demarcate
have
the
you
land.
got the instructions?
Lordship, demarcation,
Only for demarcation, my lord. Circle officer has not taken any step. That was I file a application before the district commissioner.
He is only seeking security for demand.
direct.
No. Facts are to be ascertained.
Lordship.
We'll have it on Wednesday next. You ascertain the facts at least. Heard Sri J. Ahmed, learned counsel for the petitioner. Para. This court, wide order dated 2/6/2025, had directed the learned state counsel to obtain instructions. Full stop. 3 S.S. Roy, learned state counsel. However, prays for some more time to obtain the instructions. Para. List on Wednesday next.
26, Lord.
List on 26 for motion. Ms. G. Hazarika, learned. Revenue is there?
Yes.
Learned standing counsel revenue is present.
Mate, please, Your Lordship,
Yes.
on the last occasion, they were supposed to obtain instruction. Otherwise, matter is covered by my coordinate bench, this honorable court.
Have you got the instructions?
No,
Get the instructions.
But my bank account, they have fixed it.
On Wednesday, if it is covered,
Covered,
we'll dispose this matter.
Right.
Okay.
on Wednesday.
3 A. Goel. Heard 3 A. Goel, learned counsel for the petitioner, as well as 3 H. Barua, learned counsel appearing on instruction of 3 B. Chaudhary, learned standing counsel, Finance and Taxation Department, Para. On 35/2025, when this matter was taken up, the learned departmental counsel was directed to obtain instructions. Para. At this stage, Sri Goel, the learned counsel, has submitted that the issue has been decided by a coordinate bench. Para. In view of the above, place this case on Wednesday next to enable the learned counsel for the department to examine the aforesaid issue. If it is covered, we'll dispose of. Okay. Next.
Interim order may kindly.
Is interim order is there?
There. Para.
Interim order passed earlier to continue till the next day of listing.
Review.
Item 5.
Yes, what is this?
This petition is filed against the illegal demolition of a house of the petitioner's lot by the respondent.
You have filed additional affidavit.
Well, here he claims compensation, Lord.
Huh?
Compensation, he is claiming compensation. How this court will
Compensation for what?
for
For illegal
demolition,
demolition of the
demolition of
house.
houses?
Earlier, we had approached the district commissioner submitting representation. But that was not accepted up until date.
Now, how do you assess the compensation? Which
Yes.
court? Mr. Rana?
The demolition was illegal lot.
No, illegal is okay, but how do you assess the damage? First, it has to be determined whether it is legal or illegal demolition. So even if you are successful in the endeavor, and we are satisfied that it was an illegal demolition, how do you assess the compensation? How much loss you have suffered? You have to adduce evidence.
But we have submitted an estimation, Lordship.
No, that the evidence has to be adduced. They have to be given an opportunity of cross-examination.
Let an inquiry be conducted, Lordship.
Inquiry by whom? Why? Writ court. Why is the civil court meant for?
Commissioner, Lordship, we have already approached the deputy commissioner.
You approach the civil court.
Deputy commissioner has done nothing.
So you close this, you approach the civil court, or you withdraw this. This is not a function of a writ court. We cannot go into the facts. These are disputed matters. Why do you unnecessarily add one step of coming to a writ court of with matters like this? When was the demolition done?
Demolition done on 13/5/2024.
24. You have time. You approach the civil court. heard Sri Amrana, learned counsel for the petitioner, who has approached this court with the following prayer. This 412. The learned counsel for the petitioner has submitted that the demolition was carried out illegally, and therefore he is entitled to compensation. Para. On the other hand, Sri S.S. Roy, you are also there, madam?
Yes.
Both Sri S.S. Roy, learned state counsel, and Miss Hazarika, the learned G. Hazarika, learned standing counsel, Revenue Department, have refuted the aforesaid claim and has further submitted that the matter of compensation cannot be gone into by a writ court when there are disputed questions of fact. Para. Upon considering the facts and circumstances and the relief claimed which have been extracted above, this court is of the opinion that both the aspect as to whether opinion that even if the petitioner is able to make out a case that the demolition was not authorized by law, the aspect of compensation will not be a subject matter which can be determined by this court in exercise of its powers under Article 226 of the Constitution of India. Para. In view of the above, this writ petition is dismissed. Full stop. However, liberty is granted to the petitioner to approach the appropriate civil court. Para. Dismissal of this writ petition shall not be construed in any manner to have any manner, and no opinion has been rendered on the merits of the case. Yes, next.
Item 6.
Here, Lordship, notice maybe issued, Lordship, have not received the instructions, Lord.
What is the matter about?
Demarcation, Lord.
Demarcation will.
Why Public Service Act is not?
Yes,
Yes.
why?
My lord,
Yes.
here, my lord, as per Public Service Act, my lord, after filing application, that should be acknowledged by the my lord authority. Thereafter, within 5 days, he is to dispose of it as per procedure laid down by the Section 4 of this Act, my lord.
Now what is
But they have not, my lord, they given any acceptance on the body of the application. So subsequently, petition has filed a application
okay.
for registered postman.
Okay. Heard Sri B. Rahman, learned counsel for the petitioner, who is aggrieved by the lack of, by the inaction of the district commissioner Kamrup and his subordinate with regard to the application for demarcation of his land.
Yeah.
Full stop. It is the case of the petitioner that though he had tried to invoke the Assam Public Services Act, no action has been taken. Para.
My lord, the Assam Right to Public Service
Assam
Act,
Right to Public Service Act.
2012.
2012. Para. Let notice be issued. Returnable. We'll try to dispose this on the admission stage.
Yes.
Returnable by 4 weeks. Ms. D. Hazarika, learned standing counsel revenue, accepts notice on behalf of person number 1 and 2 also. 2 are also, madam.
3
1
and
and
4
2.
I am.
Whereas 3 S.S. Roy, learned state counsel, accepts notice on behalf of person number 3 and 4. Extra copies by Monday. List for admission hearing on 18th of July,
Well.
on which date an endeavor may be made for disposal of the writ petition
Lord.
based on the instructions.
Right.
You get the instructions?
Lordship.
I love them.
Item 7.
Yes, Mr. Muzumdar.
Lordship, the status report was told in respect to the complaint dated 14/2005.
Your grandson has gone missing.
Grandson and daughter are missing from their husband, from her husband house.
The grandfather is the father and the grandfather is before the court. Who is the petitioner?
Grandmother is.
Grandmother. What is the instruction?
Lordship,
You have had a telephonic contact,
Lordship.
communication with the missing lady and her son. Thereafter,
Thereafter, my lord,
where are they? They are at Guwahati or Howli now?
my lord, that is not clear, Lordship. That phone number, my lord, which, my lord, that
Okay, we grant some more time.
Lord,
Some contact has been established.
Lord.
Okay. Heard Sri F.Z. Mazumdar, learned counsel for the petitioner, as well as Sri J. Hendik, learned state counsel para, pursuant to the order dated 13/6/2025, Sri Hendik, the learned state counsel, has obtained written instructions dated 19/6/2025. Full stop. The grievance was with regard to the status of a missing report lodged at the Howli police station on 15/3/2025 regarding missing of the daughter as well as the grandson of the petitioner. Para. Sri Hendik, the learned state counsel, by referring to the written instructions, has submitted that telephonic contact has been able to be made with the daughter of the petitioner, who has informed that she was presently at Guwahati. Full stop. The learned state counsel submits that some more time be granted to obtain further instruction. Para. Considering the above, further time is granted and the matter be listed for motion on 16th of July, just after the vacation. Okay.
Lordship, that instruction be kept in the.
Yes.
Can I have a copy of the?
Yes, you can. Please give him a copy.
Lord.
The written instruction dated 19/6/2025 is made part of the records. Next.
Yes.
Mr. Mishra?
It is covered by Lordship, so I have given a copy, my lord. Cancellation of GST registration, my lord.
Yes, Mr. Chaudhary?
Lordship, it is covered, but the reason given here in Lordship page 6, paragraph 7 and 8. Lordship, due to pandemic in 2023.
They suffered loss at that time. They could not revive the business, my lord.
That's the reason, Lordship.
An appeal was prepared, it was all dismissed, my lord.
Some people react immediately, some people react late. So he
There
belongs to
also,
the.
Lordship, considerable elapse of time.
I think it will be covered.
Yes,
Make the corrections here.
My
We'll
dear.
dispose this up. R.S. Mishra or B. Chaudhary. Baki ki nahi. Mr. Chaudhary, before you he hand over, kindly recheck again.
Yes.
Please follow. Mishra, take a copy of this. Make pencil corrections. এইটো পঠিয়াই দিব লাগিব তেওঁ সাইন কৰিব ন 9 to 2টা বজাত 9 to এটা আছিল না আমি কিবা কৰিম বুলি ক'লো না
The one, the document asked me to obtain instruction, but I have to the
No, we said that we'll issue notice. Where is the council? Okay, we'll record the names now.
This was item number 6. Huh? Oh,
Item 9 and 36. 9, I think. So 9 to kya sila? No, this will be taken up at 2 o'clock or what? Okay, we'll have it at 2 o'clock. Mr. Bonik?
May it please your lordship. And although it's a fishery cooperative society who has come as a petitioner, my lord, but nothing to do with the fishery, my lord. My lord, so far as the right to fish is concerned, there are laws in favor of actual fishermen or societies, NGOs or self-help groups formed by those actual fishermen. But so far as the selling of fish is concerned, there is no restriction on that.
Yes.
My lord.
Yes.
Now, if the fish so caught is put on the auction, that much the lessee would do, and thereafter fish goes to nearby market or far away. Now, as it goes to far away market, my lord, there has to be roadways, railways, or airway. Now,
Yes.
Just in bench format maybe.
now I'm not on fishery rights, I'm not on settlement rights, I'm not at all on any one of them. What I'm trying to say is that the district commissioner Tinsukia has held a meeting with some fish traders and the Indigo personnel and the authorities of the Mohanbari Airport, Dibrugarh, to come to a conclusion that a body is to be created by the fish traders who would certify fishes being so transported by cargo through airway. The difficulty we are putting is that
Who are you?
we are a fishery cooperative society.
No, how are you connected with?
But we are connected because we sell fish.
Okay.
Now, when they put a body which is not alien to the act, my lord, who would certify the same?
No, you do not. Do you export fish to other?
It's not about exporting, my lord.
Then
this is not about exporting at all. If I read the interim order at page 25, it says that they have created a body.
Now, how will the functioning of that body affect your rights?
My lordship, the moment I have to sell fish beyond the point, so far now, if I carry fishes which is under the schedule, the Wildlife Act, if the same fish, for the instance, my lord, then there are mechanisms under the Act the forest authorities can catch me. There is no requirement under any law for certification that such.
No, this is only for transportation of fish by air.
There is no requirement in law. But
No,
this,
how are you connected?
my lordship, if there is no requirement in law which restricts us from carrying through air, railways,
No,
roadways,
do you
whatever,
carry? Do you?
we are intending to. We have made it.
Have you done ever?
Well, this is the only point where this certification when illegal body so created will come in the way always. I am not on a public interest litigation.
No, what is your locus to check?
My locus is we as fishermen, we fish and we sell in markets. The moment we have to transport the fish, this creation of his body comes into way.
Let us see the body.
Page 25.
25, yes.
I'm not against the forest department for a moment, Miller.
That's a civil animal, man.
Yes, yes.
Forest Act.
I'm not against the forest department. This one, page 25.
And now to okay.
May I read that, Miller?
Yes.
The meeting was presided by Sri Swapnil Paul, IAS, District Commissioner Tinsukia, in response to the petition submitted by the fish traders.
You don't have locus.
My lordship,
you don't have locus. This is a very particular instance which was detected. These steps have been taken. Legality of the matter is a different aspect, but what is the locus for you to challenge?
Mother, we are the people who sell fish.
Are you selling this? Are you trying to export this?
Not at all. Not
This
at
then
all.
why are you concerned?
This is a creation of a body which on the face of it ex passive illegal.
Sorry.
The lordship would examine the matter.
Sorry.
On the face of it, otherwise this comes in the way for everything. The body is.
You may challenge in an appropriate manner by appropriate person, not by you. You are not you do not have have you made any statements that you are exporting fish
No, no,
by air?
obviously.
By air.
No,
Then are you transporting by air?
this is not at all restricted to air.
Then
The moment this body is created,
let us see. It is not restricted to air. Why is Indigo then?
they have created by air. Indigo, and so far as the authorities of Mohan Bhai is concerned,
Yes.
they have the objection. We don't know what is happening, so therefore they create a body. But the
Well,
impact is from.
This is only of the airport authority, assistant manager
Air
Indigo.
authority has come in the way so far
Whatever it
difficulties
is.
in the airways is concerned, my lord. But the applicability is always. But
Sorry.
they restrict it not to the airport.
Heard Sri S. Bonik, learned counsel for the petitioner. Full stop. Also heard Sri P. Sharma, learned standing counsel fisheries, as well as Sri S.S. Roy.
To the challenge open, my lord.
Huh?
The challenge open.
Then you withdraw it. You make it in an appropriate
Then,
manner.
Monday.
No.
And without instructions, it will be difficult.
Then
for me.
we'll dismiss it. We'll give you liberty. As well as Sri S.S. Roy, learned counsel for the petitioner, for the learned state counsel. Para. The prayer made in this petition reads as follows. Para. It is the case of the petitioner, which is a cooperative, which is a fishery cooperative societies, that the district commissioner Tinsukia had held a meeting on 16/5/2025, wherein a decision has been taken that a registered certifying society would be formed by some fish traders for certifying the consignment of fish for transport. Full stop. It is the contention of the petitioner that there is no provision in law for constituting such a committee. Full stop. Para. A bare perusal of the minutes of meeting held on 16/5/2025 would, however, show that the decision was taken on an entirely separate context, wherein an ornamental fish, including so-and-so, of so-and-so, was seen to be illegally transported through the Mohanbari Airport, Dibrugarh. Full stop. The objective of the meeting being in sync with the laws holding the field, this court is of the opinion that the present petitioner would not have locus to challenge, to maintain the present challenge by way of a writ petition. Para. Writ petition accordingly stands dismissed. Para. The dismissal is, however, on the locus and may be taken up in an appropriate manner. Mr. You're appearing, Mr. Goswami. Yes.
I just take my another.
Yes.
Well, in this case, petitioner, my lord, he has purchased one land in as back as 2008, my lord, by way of a registered sale deed. And after that, my lord, mutation and other documents has been issued to him, and landholding certificate also issued. And subsequently, my his land was, my lord,
Madi land.
but initially, my lord, there is a land grabber, my lord. So on that respect, my lord, we have
You're a land grabber.
yeah, initially, my lord. But on respect, my lord, that was
You admit that you are a land grabber.
I am not like my lord.
Then-
My land was, my lord, grabbed by the others, my lord. My lord, here, my lord, then
Your land was grabbed.
yes, my
But
land was.
then what did you
Then,
do?
my lord, whenever I lodged the complaint, when nothing was there, then
You
I
initiated proceeding under the Land Grabbings Act.
now it is here.
Okay.
Now, whenever the report was called from after initial deposition of my, then report has come, very interesting report that there is no my land, and in place of my land, other name has been shown. So in that aspect, I have lodged a complaint to the cycle officer to immediately restore my name into the my land record. then nothing has been taken in action because of my one land title suit also
Can
pending.
we give a direction? Isn't it required to be determined by
Because
civil
my lord, this-
court?
my lord, civil suit is a different thing, my lord. The civil suit is going on, my lord. I have mentioned, my lord, title suit is going on. It is in the stage of the evidence.
Then how
Now-
can we direct?
No, my lord, the action has not been.
Not the title suit. The land grabbing is a
No,
different
land
matter.
grabbing is a different thing. Two different type of, my lord, proceedings is going on. One is under land grabbing, another is under title suit.
Then what this relief which you are seeking?
My lord, kindly have a look, my lord.
Would be overlapping.
No, my lord, kindly have a look at when the first my initial.
What is the relief?
My lord, relief, my lord, my land name has been illegally, my lord.
No, what is the relief you are seeking here?
I am seeking relief that to give a direction to the, my lord, the circle officer to enter by. No, my lord, I have representation has been filed.
That will be.
No, my lord. Otherwise, my lord, they will not do anything, my lord, because they have done after, my lord, as per the 52 of the land, my lord, Assam Land Regulation Act, my lord.
It will be preempting the
Notice should have been issued before taking any action, my lord. That was not done.
It will be preempting the decision of the civil court.
Well,
having
that
jurisdiction.
will come under the civil court, my lord. I am not on like that.
Why
But
should
so
we?
far, my lord, the way of, my lord, deleting my name and entering the other.
But that is the subject matter in the civil suit. What is the civil suit for?
No, civil suit, my lord, it is regarding, my lord, that this lady whose name is now appears, she was not the party in the civil suit, my lord. This is the problem. Neither in the land grabbing nor in the civil suit.
Let us see the civil suit. Where have you stated?
I have mentioned, my lord, civil suit is going on, my lord.
Where? What is this suit about? What is the relief claimed in the civil suit?
My lord, title suit petition is, my lord, probably.
Who has instituted the civil suit?
My lord, myself, my lord.
You said that you are not there.
No, I was there. My land was, my lord, I was dispossessed. That is why
You
I
are
got
the plaintiff in the civil suit. Let us see the civil suit.
Civil suit, my lord, title suit copy is not there, my lord.
Then what is the relief you are seeking in the suit?
Sit, my lord, recovery of possession and declares to right and interest.
Then how can you preempt now?
No, my lord, between this proceeding, whenever that is going on, my lord, between these things has come new things. By way of 2016, my lord, the mutation, my name has been deleted. Not only that, the entire, my lord, others' name has been deleted.
The decision in the civil suit will govern everything.
No, my lord, my prayer is very limited, my lord. Only to the circle officer to look into my complaint. If something is found against me,
Why should he? When a court is looking into the matter,
my lord,
under what jurisdiction?
Because, my lord, they have violated this regulation for 52 of the Assam Land Regulation without issuing any notice, without giving any opportunity. They have deleted my name.
You cannot just come to a writ court with this kind of prayer when civil suit is pending.
My lord, lordship, my lord, we
are
have
dismissing.
Conduct of the, my lord, circle officer and the other official, my lord, lordship can see.
Heard Sri P. Mahanta, learned counsel for the petitioner. Full stop. Also heard Sri S.S. Roy, learned state counsel. Whereas Miss P. R. Mahanta, learned standing counsel, learned counsel has appeared for the Revenue Department para. The present writ petition has been filed with the following prayer. Full stop. It, however, transpires, Sri Mahanta, the learned counsel, has submitted that he had instituted a proceeding under the Land Grabbings Act in respect of the land in question. Full stop. To a specific query, comma, the learned counsel has also submitted that a civil suit has been filed by the petitioner as plaintiff, which is pending before the appropriate court.
Civil Judge Junior Division.
Which place? It's appropriate court, namely Civil Judge.
Title suit number 37 of 2013, mind.
37 of 2013. 13.
Yes, 2013.
Which is before the Civil Judge Junior Division, Kamrup M, which is pending. Full stop. Para.
Now it is placed for the evidence.
The prayers made in the writ petition would be clearly appears to be within the ambit of the said civil suit concerning the right, title, and interest of the land in question. Full stop. In any case, the facts sought to be projected. The matters sought to be projected are factual in nature, wherein there is a dispute with the private respondent, para. Audit court, the jurisdiction of audit court cannot be used for preempting the decision which may be taken by a competent civil court. Full stop. In view of the above, this writ petition is dismissed. Full stop. It is, however, made clear. It is, however, observed that the civil suit, which is stated to be pending since 2013, may be taken up in an expeditious manner and an endeavor be made for its early disposal.
Item 12.
Yes,
My lord, to obtain the inspection was the land was of railways or not?
yes.
This is a railway land.
Lordship, the notices that has been issued to us, Lordship, does not carry any schedule.
Yes, lordship, there is a schedule in the.
No, in the notices, Lordship. On
There-
that count also the notices are invalid. Lord. And we are claiming that
We did ask learned counsel.
Lordship, we are paying revenue, Lordship. At least the railways may be
Lordship-
asked to file an affidavit.
Lordship, let it.
Railways may file an affidavit along
This
with
is
the.
Axonia land.
No, Lordship, our
What
prayer,
revenue?
no, our prayer is that our prayer is pending before the revenue department for settlement, Lordship. The state should also come with an affidavit that our prayers are not pending regarding the status of the.
Okay, heard three, these
No,
are
Lordship,
learned
at least
counsel
the
for the,
affidavit, Lordship.
for the
Next week, Lordship,
petitioners.
before vacation, Lordship.
for the
At least the
petitioners.
affidavit.
Para, when this matter was taken up on 18/6/2025, this court had made the following order. Para. 3 SS Roy, Leonard CGC, has obtained written instructions
Yeah.
as per which the land in question is railway land. Full stop. At this stage, 3 Das, the learned counsel for the petitioner, has contended that has disputed the aforesaid projection and has contended that their application for conversion of the land from annual patta to KP patta is pending consideration. Para. Be that as it may, let notice be issued. Returnable by 4 weeks. 3. Go. State of Assam. Revenue Department. 1 as Miss G. Hazarika, Learned Standing Council Revenue.
2, 3,
Except
4.
one,
One only.
and
2,
then
3, 4 I made it.
SS Roy, CGC 2, 3, 4, J Hendrik 5 and 6. 5 and 6. Returnable Kumar question. The interim order passed earlier is, however, not continued any further.
No, Lordship, the
Maintainability of this petition may.
No, Lordship, the similar petition also pending before his honorable court, Lordship.
Let it be pending.
No, Lordship, otherwise the whole petition will get frustrated.
Let it be frustrated. We are not again. We cannot go against public interest
No, Lordship,
for your interest.
There are two issues coming, Lordship.
Sorry.
We are saying that.
We would have dismissed the petition, Mr. Das.
Lordship.
We have not dismissed. If you want dismissal, you can dismiss it.
At least, Lordship,
We are not going to pass.
Lordship may fix a date, Lordship.
Sorry.
Lordship may fix a date.
If you want either a dismissal or a notice, but no interim. It's up to you. Yes, next.
Otherwise, the whole petition will get frustrated.
You cannot help.
Then
cannot help.
it may be fixed prior to vacation, Lordship. On 20.
Okay, prior to vacation, why?
Lordship,
Is your case so important?
no, Lordship,
You are in occupation of railway land.
no, Lordship, the railway.
And you are asking, you are not even paying any compensation, and you are asking that you should be given a stay. Sorry.
Lordship, kindly
Those days are gone.
appreciate one thing, Lordship.
Public interest is
The
much more
notices,
important.
Lordship.
Sorry.
Notices do not carry any detailed schedule, Lordship. The notices are itself.
I have rejected your interim prayer. Yes, next.
Not to take any coercive action, Lordship.
Next.
Item 30.
Yes, Mr. Sharma.
May I please, your Lordship? Lordship, petitioner is a resident of Lordship, Bishnanagar, under the Lordship number 1 Hangarabari revenue village.
Yes, what is your
In that
problem?
area, Lordship, all the localities have got their electricity connection, and when the electricity connection was remain open, at that time, Lordship, the mother of the petitioner could not afford to apply or to bear the.
You want electricity connection?
Yes, your Lordship, that's why.
Yes, why don't you give?
My lord, as per the instructions, I have to, I'm waiting on instruction, but as per the paragraph paragraph 2, they have categorically stated that the land in question is not a Miadi Patta.
Definitely, Lordship.
And as for that, there is no ownership of land has been annexed with the petition.
You're giving of how is it that you are only in Miadipatta you give
No, I'm
electricity
not
connection?
that, my
Yeah?
lord. What I'm saying is
You
that
take
as
a
per ownership.
fishing notice.
Yes.
Your connection is not giving, not rest any right upon him to claim ownership of the land.
In the
That is
meantime,
a
Lordship,
basic
temporary
necessity.
connection I may be allowed, Lordship, because
Even roadside vendors, you are giving collection.
Absolutely, my lord, but there is
Okay,
some.
third Sri D. Sharma, learned counsel for the petitioner who is aggrieved by the inaction of the respondent number 3 to provide electricity connection. Full stop. It is the case of the petitioner that when the APDCL authorities had taken steps to give electricity connection to the residents, DNTS, of the locality, the petitioner was having grave financial difficulties
Yes, sir.
for which the same could not be afforded. Para, let notice be issued. Returnable on 16th of July. Sri S.P. Sharma, learned, state is there. Sri S.S. Roy, learned State Council.
1.
Accepts notice on behalf of respondent number 1, S.P. Sharma.
Or 2 and
Standing
3.
Council APDCL 2 and 3. Extra copies.
Lordship, in the meantime, because Lordship, in page number 14, I have already submitted, Lordship, the
Pendency
Yes,
shall
sir.
not be a bar
Yes,
for
sir.
consideration
Yes, my lord.
of the application of the petitioner.
My lord, he may be granted, he may apply for the temporary supply as per clause 4.5.2 and we'll get that will be.
It is also provided that in the meantime, the petitioner may apply for a temporary connection
As per
under
clause.
the appropriate provision of law.
Highly obliged.
Okay, in this case, the petitioner is agreed by the notice dated 2/6/2025, Lordship. This is
Issued by whom?
by the Assistant Settlement Officer, which the application for demarcation of the land has been ordered, and accordingly, I have served with a notice. It is at page number 22, Lordship, and at 4.
Demarcation, do you come to the writ court?
No, Lordship, what has happened in this case? What has happened in this case is Ajmali property. Prior to the demarcation of the land, I have not been given any opportunity to present my case because the unpartitioned property, my ownership right is also there. But without issuance
You
of any
file a
practice- No, Lordship, I can file a suit, but the thing is that they will demarcate the land. This will adversely affect my interest.
In a suit, you cannot file any injunction application.
At this stage, because the revenue authorities will demarcate the land, at this stage, my limited prayer is that, Lordship, this particular order may be set aside, giving me the opportunity to present my case with regard to my right over the
Mr.
property.
Chaudhary, you can afford to come to the High Court with a writ petition. You cannot file a suit with an injunction.
No, that I can do, Lordship. But
You
the
do
thing is
that.
that if the property is demarcated, that will substantially establish his right over the land,
That
Lordship.
is what we are indicating. File a suit with an injunction.
No, that I can do, but for the timing, Lordship, this particular notice.
What for the
borders
time being?
The interest of the petitioners, Lord.
Interest of the petitioner will be protected
Because
by the
he is-
civil court. Sorry.
Because he is saying that he
flood
is
the
having
writ court
absolute
like
right
this,
over the
Mr.
property.
Chaudhary. Don't flood the writ court like this.
No, Lordship, but the fact is that this
Don't
particular.
use this writ court like this.
No, Lordship,
This is
I am-
not for this.
Why I am
This
before this honorable court is because of the fact that this particular
we are
notice.
dismissing.
Lordship, this particular notice has been issued without any prior communication to the petitioners. Because when you are demarcating the land,
This cannot be a ground in the civil court. You have all the other avenues to be pleaded, espoused in the civil court. Go to the civil
no,
court.
no, option is always open, Lordship, but the
Not
fact is
option
that the.
open. It's a much wider option.
Exactly, Lordship, but the way the
If
notice has
once
been issued.
the dispute is raised by the other side, you'll be
No,
nowhere.
Why I'm saying so, Lordship, because the way the notice has been issued, this is
Heard-
absolutely arbitrary in nature, Lordship.
Heard
Because
Sri-
prior to issuance of the notice, I should have been served with the communication of the notice.
Heard
to-
Sri S.P. Chaudhary, learned counsel. for the petitioners who have approached this court under Article 226 of the Constitution of India with the following prayer quote kore dibe. Para. It is the contention of the petitioners that along with that they and the respondent number 6 are the co-parties of the plot of land which is asmally in nature. Full stop. However, without issuing any notice,
Prior notice, no.
any prior notice, the demarcation has been done,
Yes.
which
Or
would
demarcation
cause,
order.
which demarcation order has been issued on 22/5/2025, which is against the principles of law. Para. On the other hand, Sri S.S. Roy, both Sri S.S. Roy, Learned State Council, and Miss G. Hazarika, Learned Standing Council Revenue, have raised the issue of maintainability by submitting that apart from the dispute being private in nature, the same would come within the ambit of a civil dispute which has to be raised in the appropriate civil court. Para. Sri Chaudhary, the Learned Council, has submitted that the demarcation order has been issued without notice and there is violation of the principles of natural justice. Para. In the opinion of this court, the subject matter is to be decided is civil in nature, wherein disputed questions of fact are involved. Full stop. The aspect of principle of violation of alleged violation of the principles of natural justice can definitely be one of the grounds which may be taken up by the petitioner in the civil court. Para. In view of the aforesaid discussion, the instant writ petition is dismissed. Full stop. However, liberty is granted to the petitioners to approach the appropriate civil court.
Can you consider the matter for timing, my lord?
What is the matter?
Matter is the petitioner filed the petition, my lord, earlier occasion. And
Earlier,
and direction was passed. by
1591.
Lordship.
1591.
Lordship.
What was the direction?
The direction order was started from 29 and direction part is start from 50, my lord.
Yes.
Page number 50.
Thereafter, what has happened?
Lordship directed to file a petition before the authority, my lord, Secretary BTC, my lord, within 45 days. They have submitted their application within 45 days. And subsequent direction is that after submission of the application, the authorities should refer the case of the petitioner within 30 days to the referral court.
Under the 13 Act.
Lordship, under section 64. But it was that they have filed their petition in the month of February 2024.
Yes, madam, we issue notice.
Yes, Lordship. Instruction maybe.
Issue notice. You don't want notice to be issued.
Lordship, because there is a specific direction, my lord, within 30 days.
What do you want? You don't even want notice to be issued, or what?
Maybe directed to refer
First day.
Refer the case.
First day. We don't even know what are the facts. What they'll say, we don't even know.
Lordship.
You have waited for 1.5 years. If you ask this question, what is your answer? You won't have an answer. What was the direction of this court? Which date? What were you doing all this time? 30 days was the time allotted. Have you come up with contempt jurisdiction? You haven't.
No. But they have
There will be difficult questions for you if you put to you. We are not putting it to you. And you don't want notice to be issued. Third, Ms. P. Bora, Learned Counsel, for the petitioner, who is aggrieved by the inaction of the respondent authorities in referring the application of the petitioner before the competent authority under the right to fair compensation and transparency in land acquisition, rehabilitation, and Resettlement Act 2013. Full stop. The Learned Counsel has referred to an order dated 11/1/2024 of this court passed in an earlier writ petition WPC 1591 of 2021. Full stop para. Let notice be issued returnable by 4 weeks. Miss R.B. Bora, petitioner, R.B. Bora, Learned Standing Council BTC accepts notice on behalf of all the respondents. Let extra copies be served upon her by within 2 working days.
Public.
Until 17. Mr. Mohanta. Botodrava.
Botodrava. Well, a peculiar situation has arrived. They ultimately.
How many litigations?
Sorry. What went up to the. This honorable court dismissed the petition.
I think you will also break the record of Demoria College. Demoria College used to be the, I think, the record holder.
Is it?
Yes.
Now-
Demoria is in Morigao, isn't it?
The
The number of litigation, I think the maximum. Next would be Botodrava, I think.
Oh, yeah. So from my information goes only one suit filed by them. And that of course came up to this court and went up to the apex court.
Now, what is your difficulty?
Now my difficulty is, my lord, while they didn't hand over the office, all.
Now, you said that the order of the Honorable Supreme Court has not been implemented.
Implement. It is.
Can you come to the writ court?
My lord, my only requirement is that when the other side is not cooperating and they are stumbling block, they are standing as a stumbling block. And
You moved the Supreme Court with contempt.
No, my lord, here directly kindly see the order. It was 123. Yeah.
No, but can the writ court be made in the executing court?
Now,
for
I
the-
want that the district authority should give the assistance. I am asking for that kindly magistrate, they put an officer in who is present.
I think
who is there.
maintainability would be an issue.
Now, my lord, here kindly consider that the decision order of the apex court, which must be an obligation cast on me, must be taken as an obligation, a direction to complete it.
Okay, Mr. Taruda. Okay, Mr. Medi. Yes, take instructions.
Therefore,
we issue a short notice, but I think maintainability will be an issue tomorrow.
Let
KK
notice go, my lord.
KK Mohanta, Learned Senior Counsel, assisted by Miss
N.
Begum for the petitioners. Full stop. It is the case of the petitioner that a title suit which was instituted, by the respondent numbers 3 and 4.
Yeah.
Being title suit number 123 of 2024.
Yes.
Was decided and had finally reached the Honorable Apex Court, in which an order was passed on 3/3/2025. Correct?
Well.
Full stop. However, the district authorities have not provided the amenities to facilitate implementation of the order of the Learned Apex Court, of the Honorable Apex Court. Para. That notice be issued returnable on 21st of July 2025. Ms. Sri P.K. Medhi, Learned Counsel, assisting Sri B.J. Talukdar, Learned Additional Senior Advocate, accepts notice on behalf of respondents 1 and 2.
Not one, only two. One is represented by P. Nayak.
GAD?
Yes.
GAD, yes, P. Nayak. Anyone with Nayak? GAD? Okay, is he there in the court? Oh, then P. Nayak, huh? 1. and that's what PK Methi assisting so and so for 2 extra copies within 2 working days. Steps for service of notice upon the response 3 and 4 by registered
By
dispute AD by Monday.
Pendency may not be a bar to consider my representative. By the
Pendency shall not be a bar for consideration of the representation said to have been submitted by the petitioners
before the district of.
by the district commissioner. Yes.
May I pray that date may be preponderant because my ultimate Supreme Court director, I am to comply with my.
No, next week it does not, it will not be possible thereafter vacation.
After vacation, immediately.
We have said, Kiman Kusa, date 20? We can have it on 16th then, if you say 16th.
Yeah, because I'm.
We are reopening on 14th, we'll have it on 16th?
Yes.
Okay, 16th.
Deeply.
Madam, take steps. 18. Still a bond code.
May it please, Your Lordship.
Yes, Mr. Gola.
My lord, a suit is pending, my lord, for my lord adjudication before the civil court, my lord. Circle officer.
You are the plaintiff.
My lord, no, I am for the my lord defendant,
okay.
number 17, my lord.
Thereafter,
my lord, circle officer also as a party, my lord. Circle officer file, my lord, WS, my lord, page number 35, my lord.
Then what is your case?
My lord, circle officer, my lord, stating that, my lord, the land is disputed, my
You
lord.
cannot file an injunction.
My lord,
He has issued a patta. Why don't you file an injunction? Suit is pending.
File
an injunction application. Why do you approach 2 forums for the same cause of action?
my lord, the suit is pending for my lord simpliciter suit, my lord.
Doesn't
Suit is
matter.
simpliciter, my lord.
The issuance of patta is affecting your rights.
My
You
lord.
file an injunction till the suit is disposed of. You pray for an injunction.
My lord.
Then you can come to a higher superior court if it is permitted by law. How do you come to under writ court?
Lord, but my lord, the DC has power to my lord cancel the patta. my lord.
Will the civil court be barred in law to adjudicate a
No.
matter of to?
My lord, my representation also my lord pending before the my lord deputy commissioner. My lord.
You cannot. Commissioner cannot do anything.
My lord, but my, during the pendency of suit, my lord, the patta has been issued, my lord.
So
Why-
what is the difficulty in filing an injunction application?
Right?
You advise properly, unnecessarily. Heard 3 HP Goala, Learned Counsel for the petitioner. Also heard revenue. Also heard Sri BJ Taluda, Learned Additional Senior Advocate, as well as Miss P.R. Mohanto, Learned Standing Counsel, Revenue Department. Para. The case, the facts, please have your seat. Facts projected by the petitioner is that the respondent number 5 had instituted a title suit 11 of 2022 against the petitioner and other defendants in the court of the learned civil judge, junior division, Soradio, in the district of Soradio is different district or Sonitpur, Sonari district?
Different district.
In the district, in the Soradio, for declaration of right, title, interest.
My lord, right interest.
Right interest and possession. Full stop. It is the case of the petitioner that the circle officer, Nazira Revenue Circle, is a defendant in the suit who had also submitted the written statement. Full stop. However, during the pendency of the suit, the said circle officer has issued a patta in favor of the private respondent on 26/6/2024. Para. While it is not this, it may not be disputed that the rights of the present petitioner has been adversely affected by such section, comma. This court is of the opinion that instead of approaching this court under Article 226 of the Constitution, comma, the petitioner may file an application for injunction before the same court where this title suit is pending, full stop. The petition is accordingly dismissed with liberty to approach the civil court, full stop. If such an application is filed, the same be considered strictly in accordance with law.
Oblige, my lord. 19 is same, my lord.
19 same.
Same.
Parties?
Same parties, same.
18, respondent by 18.
My lord.
Okay, same. Title suit number 12 of 2022 hobo. Ago to kiman asil? Title suit?
11.
11, it is 12 hobo. Huh? Okay. Okay.
Oblige.
Item 20.
Lord, kindly take it up after some time. That is, Portakur will appeal.
What is the matter?
Lord, notice is issued for
Eviction
by the Forest Department, although we are on revenue land. That is a. Those are not notice of eviction, but they are asked to produce their documents.
Produce the documents.
They say they have. We have responded, my lord.
Oh, then?
Now they think that we'll evict them, but there is a process of settlement going on, a proclamation going on. The settlement officer is deciding.
We can issue notice.
In similar matters, there are stay orders. Those are not similar, my lord. Those are, my lord, the settlement process.
No, Mr. Gosame says something else. We'll record his submission and the process is also going on. We'll issue notice, we'll make it returnable in the reopening.
Kindly take up after some time.
Okay, let Mr. Bhatta come.
Not obliged.
Item 21.
May I please, Your Lordship? My lord, this matter relating to non-payment of the share of the petitioner's lordship amount of compensation, lordship. Lordship, what has happened, lordship? The petitioners are the lordship legal heirs, and as after death of their predecessor in interest, lordship, they are the owner and possessor of the landlord. And subsequently, lordship, TA notification was published for acquiring that plot of land, lordship. That number 476.
National Highways Act. National Highways Act. Yes, then.
So thereafter, lordship, although lordship, we could not able to procure the TT notification, lordship, but now lordship, we had that lordship, respondent number 9 and 10 with in collusion with some officials, lordship, they are trying to take away the compensation amount for with regarding to that landlord.
You don't have any other revenue.
Sorry, lordship.
You don't have any other revenue for redressal of your grievance.
Lordship, we already filed a representation before the authorities.
Not representation. Under the Act.
Under the Act, lordship.
Under the Act. Mr. Talukdar?
Lordship.
Yes.
Under the Act, Lordship, they have to approve the Lordship 3H, Lordship, 3H4.
Yes. 3H. A court has been designated for inadequacy, adequacy, apportionment, everything. How do we determine?
Lordship, because we already approached them, lordship.
Not them.
Lordship,
They are
competent authority.
they are not the adjudicating authority.
Lordship, we required to file a application before the competent authority, and we filed, lord.
Yes. Which is the competent authority?
Competent authority is Kala, lordship. Deputy Commissioner, lordship.
Lordship, Deputy Commissioner is the not the competent authority of planning. Additional Deputy Commissioner, Lordship, he is the competent authority as per that.
Now, where is your approach to Kala?
Lordship, through the
where? Which
lordship,
page?
Page number 23, lordship.
That is not Kala, Lord.
He approached the appropriate authority.
Through the land acquisition officer, we have filed, lordship.
23. Page 23. Let us see. District Commissioner.
Competent authority is the
You
additional
approach
District Commissioner. He is
the competent authority.
yes, Lord.
They are equipped with the expertise to adjudicate this kind of disputes.
We filed it through the land acquisition officer, lord.
Now, where is the address? Whom have you addressed? Is
Yes,
it addressed to the Kala? No.
No, Lord, that district commissioner is the lordship.
No, no. Additional district commissioner is the competent authority of the district.
We are examining this matter in the context of 2H of the National Highways Act of 1956. 3H, isn't it? 3H.
Yes, sir. Yes, sir.
3H.
And if any dispute, lordship.
3 and 4. 3 and
Yes,
4.
Lord.
Yes, 3 and 4. If dispute arises of the apportionment, he approves that authority.
Lordship, this is regarding apportionment of the amount. Lord.
Yes. Apportionment.
Yes,
Yes,
he
Lord.
is stating
But
that.
here, Lordship, we claim our part of the compensation.
What is the meaning of apportionment?
That is apportionment, lordship. We stated that private, they are
What
going
is
to
the meaning of
disburse to
apportionment?
the private respondent.
Apportionment is division. Your part, their part, it will be divided. How much is your share? Okay. You appraise that authority.
They shall then consider.
Obviously, obviously.
Effort.
Is there any time prescribed? No time.
There is no time limit.
Okay.
Lordship, till any decision, Lordship, taken by the authority, Lordship, the payment shall not be disbursed. Otherwise,
You
Lordship,
make an application there. There will be.
Lordship, your Lordship may kindly observe that part,
Okay,
Lordship.
okay.
Otherwise, Lordship.
Okay, heard free and H. Borbia, Learned Counsel for the petitioners. Also heard Sri R.K. Talukdar for the National Highways Authority.
Lordship, 4 and 5, lord.
Over 4 and 5.
NHIDCL.
NHIDCL.
6 and 6.
Comma, Miss Sri B.J. Talukdar, Learned Additional Senior Guard Advocate, and Miss P.R. Mohanta, Learned Standing Counsel Revenue Department. Para. As per the facts projected, the petitioners are the legal heirs of one Aftab Uddin Laskar, who has been stated to be the owner and possessor of a plot of land. Measuring what? Of a plot of land covered by dag number. देख लीजिए हाँ 476 second RS Patta 128 under so and so. Full stop. The names of the petitioner have been mutated on the strength of the right of inheritance. Full stop. The Ministry of Transport and Highways, Government of India, had issued a notification under Section 3A of the National Highways Act in January 2024 for acquisition of land which would cover the land in question. Full stop. Though the petitioners have represented for release of land compensation, the same has not been released to them, and it is the projection made that the compensation may be disbursed to some other persons in collusion with the officials. Para. Sri R.K. Talukdar, Learned Standing Counsel, NHIDCL, has, however, submitted that there is a statutory remedy provided under Section 3H of the National Highways Act of 1956. Full stop. Specific reference has been made to 3H within bracket 3 and 3H within bracket 4. Full stop. The Learned Counsel for the other respondents have also endorsed the aforesaid view and has submitted that the petitioners may approach the said forum. Para. At this stage, Sri Borbia, the Learned Counsel, has submitted that representation to the District Commissioner Kachar was already made on 3/3/2025. Para. Sri Talukdar, the Learned Counsel, has, however, clarified that the appropriate authority is CALA.
Additional District Commissioner.
CALA,
Yes.
which is headed by the additional district commissioner, Kachar, full stop, para. The dispute which has been raised would definitely involve factual determination, which this court, in exercise of powers under 226, may not be in a position to enter. Full stop. Juxtaposed, the statutory provision referred above would be an efficacious remedy which the petitioners can avail, para. In view of the above, comma, the writ petition is dismissed, however, with liberty to the petitioners to approach the appropriate forum, para. Sri Barbia, the learned counsel at this stage, has expressed an apprehension that the amount may be released in the meantime. Full stop. It is observed that along with the applications that may be filed, the petitioners may also pray for any interim order in which, full stop. In such a case, comma, such interim order is required to be considered in accordance with law.
Like.
Disposal. Yes, next.
Item 20, Tanveen.
Yes.
May I please, Your this case, Your Lordship, the petitioners have put to challenge, Your Lord. The notice, Your Lordship, which is the page 382, Your Lord. One block. Our case essentially is this, Your Lordship, this is without any jurisdiction, Your Lord. First of all, Your Lordship, even going by their own admission, Your Lordship, there is a proceeding going on, Your Lordship, under the Assam Forest Regulation, Your Lord, where, Your Lordship, a proclamation notice has been issued, Your Lord. Now, during the pendency of that proceeding, Your Lordship, probably this could not have been issued, Your Lordship. Number one, Your Lordship. Number two, Your Lordship, the RTI applications, Your Lordship, filed by us has clearly stated that, Your Lordship, this area, Your Lordship, this area does not fall within the, Your Lordship, proposed reserve forest, Your Lordship. The others, Your Lordship will get it at page 657, Your Lordship.
Now, Mr. Goswami was submitting something else, that they are not proposing to evict you.
Lordship?
There is no proposal for immediate eviction.
No, Your Lordship, why
They're
we
only
are
asking for your the documents. Which
no,
you
Your
have already-
Lordship, there is a reason, Your Lordship. I will show that, Your Lordship. Your Lordship, if that is the case, Your Lordship will kindly see page 649. A notice issued by the APDCL for disconnection of our, Your Lordship, electricity in view of the imminent eviction, Your Lordship. How can it be, Your Lordship? If there is no proposal to evict us, we have already replied. We are apprehending, Your Lordship, since they have issued this notice by the APDCL saying
yes,
that,
yes.
Your Lordship, that is at 649, Your Lordship. Notice for disconnection of electricity.
My lord, the notice that they have challenged, my lord, page 382. Nowhere indicates, my lord, that they will be evicted. Okay, in the meantime, APDCL.
No, the apprehension with connection with APDCL.
There are two cases filed earlier, my lord. In those cases, there is a direction not to evict, but there was also, Honorable Court also allowed us to proceed with our proclamation process.
That is there,
what was my submission? In those two cases, my lord, the proclamation was not under challenge. Now, after my submission made in before the court, Honorable Court, my lord, now they have in this proceeding, my lord, challenged the proclamation also. Where therein I have objection, my lord.
Your Lordship may not, Your Lordship may not be able to say
they
this.
now want to get an absolute interim order,
No.
which will bar us from proceeding with to declare that as a.
No, that we are not touching now.
That
Same
clarification,
order.
you know, my lord,
Same
can-
order.
That we are not touching now.
my lord, kindly pay this.
No,
the
we
prayer.
go ahead with the proclamation
Yes,
proceeding.
my lord, kindly 2 minutes, my lord.
No, we go ahead. We are not barring you.
Only, my lord, the prayer.
You have a look at this order. You have this copy.
In his presence, Your
I
Lordship,
appeared there,
that
my
has-
lord. So my only prayer is, my lord, let there be a stay as regards the impugn notice is concerned, but there should not be any, my lord, restraint order for us to proceed for the settlement, my lord.
Lordship,
Because
that-
that settlement also.
We are not in the mode of passing a stay order. You have admitted. Now we have to pass.
I'm not saying so, my lord.
You said so. Let there be a
That's what
stay.
I'm saying, my lord. Let there be no stay order as regards the proclamation is concerned. Because, my lord, proclamation
But
will
you said
finally.
let there be a stay for the eviction. Eviction also we are not inclined to pass.
Yes, my lord will kindly see page 49 for a moment. my
Okay,
lord.
I heard we, as Bothakul learned counsel for the petitioners who have approached this court primarily against notices issued to the petitioners, all 27 May.
There are 17 May also, my lord. Two types of orders.
Issued to petitioners dated 17 May 2025 and 27 May 2025. On the subject of unauthorized use of forest land in what is PRF? Proposed reserve forest areas. We did bracket PRF. Sir, the learned counsel has submitted that on earlier occasions, similar petitions have been filed wherein the eviction aspect has been stayed. Full stop. He has submitted that by the notices issued by the APDCL for disconnection, the eviction becomes imminent. Para. On the other hand, Sri P. N. Goswami, learned, he appears and learned AAG has submitted that the facts in the earlier cases are not identical, in as much as in those cases, the proclamation as such was not the subject matter of challenge. Full stop. He has submitted that the notice for disconnection by the APDCL would only be a consequential step in case any action for eviction is initiated. And at present, only the documents are sought from the petitioners with regard to their possessory right. Para. Let notice be issued returnable by 6 weeks. You for all?
Find a no police no.
1, 2. Thank you. One by my planet friend member.
One revenue.
Yes.
One. District Commissioner also, I think, who District Commissioner will be taking 2, 3, 4, 5, 6,
7.
APDCL also.
Yes, ma'am. And 8.
7 and 8. By 3. P. N. Goswami. Let extra copies be served upon the learned counsel for the respondents by Monday. Para. 3. Bothakul, the learned counsel for the petitioners, prays for an interim order and has also placed on record earlier orders passed by this court in similar matters. Para. After hearing. Sri Goswami, the learned AAG, has submitted that, has reiterated that there is no immediate move to evict the petitioners. Para. In view of the above, it is directed that till the next date fixed, no action be taken for evicting the petitioners from the land under their possession, and the electricity connections are not to be disconnected.
But only thing, my lord, this eviction pursuant to this interim office.
Yes.
That is relevant because, my lord, there is a separate proceeding going on for declaration of
It is, however, made clear that the proceedings initiated for proclamation, the proclamation proceeding initiated has not been stayed by this order.
Deeply, please.
61 and 62.
Motion making. Yes, 61 and 62.
But they were supposed to file opposition, they have not yet filed.
What is the matter?
But the issue is about, my lord, the concurrent jurisdiction exercised by, my lord, the state as well as
Yes,
the center.
madam.
Your Lordship, my senior SCKL sir is on legs. It may be taken
Who?
off vacation. Mr. SCKL, your Lord.
SCKL.
My lord, you can be the Pico appears for this matter, my lord, with occupied court number, my lord.
But have you got the instructions or affidavit? You have not filed.
Not yet, my
They have
lord.
not yet filed.
Then,
But kindly give it after vacation, madam.
since you have not filed, we will definitely seek for time to file affidavit.
lord.
Let it come after the vacation.
My lord.
Okay.
Let
but
the interim stay continue.
that we'll consider. When? Give a date.
But
There's an
then-
interim order.
Immediately.
My lord, 22nd, my lord. 22nd of July.
You are V. Sharaf.
Yes, my lord, I am V. Sharaf.
Heard Sri V. Sharaf, learned counsel for the petitioner. Petitioner who has who by referring to the order dated 16/5/2025 has submitted that time was granted to the respondents to seek instructions as well as file affidavit as a preliminary objection to the maintainability was raised. Full stop. However, this court had also provided an interim protection by directing that no coercive action be taken. Para. The affidavit has not been filed. Para. Let notice be issued. Returnable on
22nd July, my lord.
on 23rd. Is it okay? 23rd.
25th in that case. my lord.
25th of July, 2025. Yes, who's accepting? Mr. H. Barwa, learned counsel, appearing on instruction of Sri B. Chaudhary.
B. Gogoi, my lord.
B. Gogoi. Standing counsel, finance and taxation. Accept notice on behalf of respondent 1, 2, 3,
1, 2, my lord. 4.
3. What about 3?
4, my lord. 3, my lord. Yes, my lord.
3,
3.
4.
No, my lord. 4, I'm not appearing.
Why? GST.
GST, my lord. Central GST, my lord.
You have not said central GST.
Central GST, Mr. Kayal appeal.
No, 4. How have you described 4? What is the
GST
description of 4?
Central
CGST.
GST, my lord.
1, 2, and 3. Then what about 8?
8, my lord. 8, I'm at
8, 9. 8, 9 also.
9.
8, 9.
9, my lord. Yes.
8, 9. Whereas, yes, madam, your name. Ms. P. Upadhyay, learned counsel, appearing on instruction of Sri S.C. Kal, senior standing counsel, CGST, accepts notice on behalf of respondent. Baki sab dekh kar ji, yeah? Let extra copies be served upon the learned counsel for the respondents by Monday. Para? Till the next date fixed. The interim order passed earlier to continue.
Great.
Obliged, my lord.
The aspect of maintainability of the writ petition is, however, kept open.
63.
61, 61, 62 are common. Mr. Saraf? Both the writ petitions are similar.
They are connected, my lord.
Connected. And the respondents are the same.
Subject from the same subject.
No,
matter.
respondents are the same or not?
The respondents are the
Okay. Numbers are also same.
same.
Mr. Barwa, if there's any disparity, just inform her. Okay. Yes.
That is your lordship. My lord, this matter, earlier we have, my lord, submitted that, my lord, by the petitioner are in possession of the land since 1997, my lord.
1997.
97. And since 2002 to March 2025, tax is paid and it is received by the authorities concerned, my lord. Duly received.
What tax?
My lord, 2002, from 2002 to 2025, my lord.
What tax?
My lord, it is received by the
What is the tax?
municipality, my lord.
Municipality tax.
Municipality tax. My lord.
Let us see.
Kindly have a look, my lord, at page, my lord. Page 26 to 33, my lord.
26.
26 to 33.
This is holding tax.
Yes, my lord. The holding number 01802, the number is changed again, my lord.
Okay, holding tax.
Yes.
Paid to whom? Dhubri municipality.
Yes, my lord.
Yes.
Page 33, my lord, that is 2520 in the year 2025 is also received, my lord.
No, Mr. Talukdar, your primary contention was regarding the notice.
Yes, I'm coming to that, my lord. My lord, thereafter, my lord, kindly see page 34, my lord.
34.
On 34.
Yes.
This is, my lord, regarding submission of report, my lord. The petitioner have filed a petition for allotment to the Deputy Commissioner Ketan Dubli. After filing the several petitions filed, lastly, ultimately one is taken care of, my lord, and the Deputy Commissioner sent a letter. Kindly see the reference number dated 5/8/2009 by DRS number 10/2007/162 to Circle Officer.
Yes.
Circle Officer Dubli for a report on this.
Yes.
So after, my lord, field inquiry and, my lord, this is filed that, my lord, with reference to the above, I have the honor to submit here with the settlement proposal of government cash land measuring so lesser covered by DAG number 61674 part out of land measuring 1 kata 16 point half lesser under Dubli town Kasmahal for settlement of the petitioner Sri Sakerali so of village Kuntirsor Dubli. The petitioner Sri so is constructed a shop on the proposed land and possessed the same since 5 years, my lord. So 5 years is not the correct, my lord. There is no valuable tree on the proposed land, and the proposed land is situated 32 feet, my lord. Kindly noted, my lord. This is maybe important, my lord. 32 feet outside from the middle point of PWD road. The proposed land is situated in a bank of on the bank of the Godador River. The petitioner has submitted voter list on 2005 in his name and 1960 of his father's name. Chita copy trace map format along with all connected documents that can share with for your favor of information necessary action, my lord. Then, my lord, kindly turn to page 37, my lord.
37.
Page 7, my lord. This is dated, the circle officer issued this possession certificate to me, my lord, dated 5/2011. Certified that land measuring so lessas, 5 lessas out of 16 katas, 16.5 lessas covered by DAG number 1674 of Dubli town, Kasmahal, and under Dubli circle is government land. The name of the Sakir Ali Habibur Rahman is mentioned in the remarks column of Chita of the land is at present under its possession. My lord, electricity line is there, and with having the drug license and trade license issued by the, my lord, by the Dubli Municipal Authority. My lord, I have annexed through series, my lord. Annexer, my lord, page 9 and 19, my lord, onwards, E-series, my lord. There are trade licenses issued to my pharmacy known as Royal Medicals, my lord. It is up to date, my lord, till 2026, 31st March, it is, my lord, up to date, my lord. My lord, thereafter, my lord, kindly see by page 22 series, my lord, the drug license, my lord, I have obtained since 2017. In my lord, the petition number 2, and it is up to date also, my lord. It's till March 2000, till 19 to 2027, my lord. Thereafter, what happened, my lord? Kindly see the page 39, my lord. 39 to page 43, my lord. Electricity connections, bill payment, and all these things, my lord. Then, my lord, kindly come to the affidavit in opposition filed by the government, my lord. The respondents kindly take it, my lord. Kindly turn to page 47, paragraph 6, my lord. That with regard to the statement made in paragraph 5, the petitioner, the answering deponent begs to state that a proposal for settlement of the said land was submitted by the circle officer Dubli, but clearly due to non-qualification of the petitioner and the land parcel for which settlement was sought for, the proposal was not accepted by the subdivisional land advisory board. no further progress took place with regard to the petitioner's claim. It is pertinent to mention here that the scheduled land falls within the reservation of waterside area, i.e. 25 meters from the Godadar River, which is not fit for settlement as per land policy 89 and 19, my lord. Now, my lord, kindly see, till date, my lord, so far as my information is that, kindly see, there is no date of, my lord, rejection. There is no minute copy is annexed, my lord, on which date, who were the members, how it was, my lord, rejected. My lord, there is no final order of rejection. Nothing in next, not even the date, not the minutes, not the order. Nothing in next. Only just my lord back submission, my lord, which is absolutely incorrect, my lord. Till it is pending in the DC's office, my lord, till not decided, my lord. I have the source and the information to my lord, and not giving the copy anything. They are not supplying now anything, my lord. My lord, kindly see, my lord, see that paragraph 8, my lord, that with regard to the statements made in paragraph number 7 of the petition, the answering deponent states that possession certificate may be issued to encroachers on government land of various purpose, but it does not confer any ownership right to the encroacher. Definitely, my lord, I have no final ownership right, my lord. That is true, my lord. But once some right is given it to someone, my lord, he should be heard, duly heard before rejecting the same, my lord. He should be given sufficient time and for his, my lord, reply and for natural justice, my lord. That is not done, my lord. Kindly turn to page paragraph 10, my lord. That with regard to the statement made in paragraph 12 of the petition, the deponent states that the respondent number 3 is empowered to evict illegal encroach occupiers from vacant government land as per government notification number so and so, and notice number DBC number 720/2025/B dated 13/6/2005 was duly served as per rule so and so, my lord. My humble submission is that till date it is not, my lord, furnished to me, my lord. Number 1. Number 2, kindly took the, my lord, a copy of the said notice, my lord, page 51 annexure 1, my lord. Kindly take them. See, my lord, the issue number, my lord, number DBC 07/2025/33. Kindly see here, it is a different letter, my lord. Quite different letter in paragraph 10 mentioned. It is DBC 725B, capital B, and actual they have annexed, it is 7/2025/33, my lord. It is a different letter issued to me. They are still not aware of what they have done, my lord. Because immediate, my lord, manufacturing all things in a short span of time, my lord, only to satisfy the honorable court wrongly, my lord. All these things are done, my lord. My lord, kindly turn to the below, my lord, Mati Kali, my lord, page 51, my lord. It is scheduled, my lord, that 1 quota 16 lesser. That is also, my lord, to mislead and misguide this honorable court. Only 5 lessers, my lord, land to show that actually only 5 lessers in my mind.
Sir, before you make an allegation of misleading,
my lord,
kindly read the entire averments in paragraph 10.
Yes.
What is the first reference?
Yes, ma'am. Then
This
the
is
regard to the
2010 notification. What is the notice dated? DBC 7/2025B.
My lord.
What is the problem here?
My lord, number is different quite, my lord.
Where?
My lord, it is the 07/2025/33, my lord.
Yes, B. Then dated 13/6/2025.
Date may be same, but letter is different, my lord. Quite different, my lord. That is capital B and it is 33, my lord.
33. We'll see the records. What is the problem? What is the problem?
That is supplied to me is a copy, my lord. That's why, my lord, my submission, my lord. This is my humble submission, my lord. This is quite different letter, my lord.
Not different.
My lord, it is
mentioning of B instead of 33. If it is a genuine mistake, what is the but if it is done intentionally, then it's a different matter.
My lord, kindly see now, my lord, kindly see this will, my lord, kindly corroborate, my lord. 1 kata 16 lesser, that is they are saying scheduled land in my possession is absolutely incorrect, my lord. Only 5 lesser, my lord. My lord, only to give an impression before your lordship that I am occupying a big land area of land, my lord. Only to this is misguiding and misleading, my lord, clearly, my lord. My lord, only 5 lessers of land in the possession certificate. It is also clearly mentioned, my lord. And I myself also saying so.
The certificate is how much?
5 lesser, my lord.
Let us see. Page 37.
Yes, my lord. Page number
37.
37. Yes, my lord.
Yes.
My lord, certified that land measuring shows 5 lessers, my lord. 0 bigger, 0 kata 5
Out of.
Yes, my lord.
This is the total area.
Total in the
1
same
kata
number.
16.5 lecha is the total area.
My lord,
this notice which has been issued is for the entire area,
My lord,
out of which five lectures may be under your possession.
my lord, kindly see that there is in the possession certificate, it is saying that in the dag number so and 1674,
Yes.
one kata,
Yes.
16.5 letters.
Yes.
And here, my lord, schedule is regarding my possessed land, my lord, occupied land.
Yes,
In the notice.
your land is not under this schedule.
Under this, but
Then-
I am only 5 lectures, my lord.
So 5 lectures is not
But
a part
maybe-
of one katha.
My lord, it is giving an impression that I am occupying the entire, this is tafsil land, my lord.
Not necessary.
My lord,
How will it make a difference in the decision-making process?
my lord, the number one, my lord, that, then my lord, kindly, they kindly come to the annexer, my lord. Annexer of the evidence opposition, page 52, annexer 2, my lord.
And this possession certificate is for whom?
Sakir Ali, my lord.
Sakar Ali, and this notice is for whom?
Notice is for,
Is it for Sakar Ali alone?
yeah, my lord.
Please, Mr. Talukdar.
Tajul Islam, my lord, that's his son, my lord, the same land, we have the same land, my lord.
Two individuals.
No, my lord.
And the entire land has been stated as one katha. What is the wrong?
No, my lord, there I have mentioned that in the stated in my case, my lord, in my
Your
petition,
entire
I
contention-
am only with the 5 lesser, my lord. We are only 5 lesser.
Is 5 lecha a part of this one katha, 16.5
Yes,
lecha?
yes.
Matter answer.
My lord.
You are contending that the notice was not issued.
My lord,
Now
kindly-
notice is there.
My lord, kindly turn to page 52, my lord.
Where is your reply that notice was not issued?
Yes, my lord, I have kindly take the evident reply, my lord.
Yes. This notice is there. Yes.
Paragraph 4, my lord.
Hmm.
The document to show the stay must serve, my lord. Paragraph 4 and paragraph 5 also, my lord, kindly see, have a look, my lord.
Hmm.
The paragraph number 6 of the affidavit in opposition filed by the respondent, it is absolutely incorrect. The proposal for allotment of land in question was never placed before the district land treasury board till date.
We are not on that. We are on the notice part. Your entire contention was that notice has not been served upon you.
My lord,
Where is the reply to paragraph 10?
paragraph 4, my lord, of my reply, my lord.
Of paragraph 4?
Yes.
Yes. Where is your reply to paragraph 10?
Well, exactly, my lord, I have short affidavit, my
You
lord.
have not even, you
I
have not even contended, you have not even confronted paragraph 10.
My lord, the same thing I have mentioned here, my lord.
No.
Not paragraph
No,
which I
no.
have made it, my lord.
Sorry. These are writ proceedings. Only pleading says there's nothing,
My lord,
nothing
I
more
have
than
got
that.
it by the evening, my lord. Filed it in the next morning by 10 your lordship, you know, in a
You-
hurry, my lord.
you have not-
And I have mentioned in the short affidavit just to brief your lordship the in reply.
It is not a sort of, you have dealt with all other paragraphs, you have not dealt with paragraph 10. You have not even replied to paragraph 10.
Yes, my lord.
Where?
Paragraph 4, my lord, I mentioned that, my lord, clearly.
Where?
Kindly have a read, my lord. That to fail to annex any document to show the same was served upon the
Mr. Talukdar,
by showing the same, my
Mr.
lord.
Talukdar,
My lord.
please submit in a fair manner. If you have replied to paragraph 10, please show us. We have not found here any reply, not even an evasive reply.
My lord, that is.
You have not even dealt with paragraph 10.
My lord, the paragraph.
All along with the
regarding
content
notice, my
on that-
paragraph 10 mainly deals the notice, my lord.
You are on contending to notice.
Yeah,
You are saying that
in
I
my
can
paragraph 5,
say.
I have clearly mentioned no number issued, it is wrong, incorrect, my lord. Maybe, my lord, the only paragraph number is not mentioned, my lord. But the substance is there, my lord. Now, and my lord,
Mr. Talukdar, don't make up. You are not a lawyer of yesterday. You have been practicing here.
my lord.
Read code. How do you decide a writ petition? Is there any avenue of evidence here?
My lord,
It
my
is the
lord,
pleadings which are sacrosanct.
my lord,
Pleadings have to be verified. You have not even dealt with this
my
pleading.
lord,
Nothing.
my humble submission will be, my lord, minus the, my lord, in addition to the, my lord, this notice, my lord. I have my proposal for allotment is still pending, my lord, not decided, my lord.
Okay.
And in pending
Yes,
person,
yes.
they cannot keep it like this, my lord. They should decide it first, my lord. And it is pending, my lord. There is no mentioning that regarding minutes, numbers, dates, or anything.
You have made your submission. Yes.
So far as surveys is concerned, okay,
Hmm.
although we have written in paragraph 10 that on that notice of 13/6/2025 was duly served. On that day, he was informed. 14th and 15th, his shop was closed. On 17th, when our person went there, he was attacked. May I read this? The final information I have received, Lordship, in writing. The notice of eviction issued on 13/6/2025 was attempted to be served by the process server of Circle Officer Dupri on 17/6 because prior 2 days were closed. But the petitioner refused to receive the same. Instead, he held the process server captive and kept threatening him by videographing him and started calling other people's over phone. After about 30 minutes, the petitioner fled from the spot. The police came and he fled. The process server waited for another 30 minutes and thereafter returned to office. Subsequently, on 19/6/2025, yesterday, another service notice was attempted, but the shop was found closed. The notice was then pasted on the door of the shop, and a copy was transmitted to the petitioner via WhatsApp in the number so and so. It is further reiterated on 13/6/2025, officials from Dhubri Circle Office and Dhubri Municipal Board gave verbal intimation to the petitioner and other shopkeepers to voluntarily dismantle their encroachment. The shop was found closed on 14th and 15th. So this is his attitude. In fact, here also I wanted to give a copy to the other side's counsel. He refused. So what is the situation in Dhubri? Lordship can well imagine. So he refused to accept the notice. Yesterday, the process server pasted it on the shop's wall. These are photographs I have received. So he is deliberately avoiding the notice.
No, that he has taken a shift. All these days when the matter was taken up on 2 occasions, he said that I can see it with conviction that notice have never been issued. That was the stay. That was the stand.
That was the first stand.
Stand. Now, when the notice you have produced, he said, let it be on affidavit. On affidavit, he said, I want to file a reply. Reply, he does not even deal with this averment.
And on writings, I have received all this information.
My lord,
he tried to attack our process server. So we have not filed the FIR because it's a status quo.
Those facts, though, may be very relevant,
Very
in
relevant.
adjudication of a writ proceeding, which is a court of equity.
Yes.
But unless though you put
Yes,
this
I
on
will have to file
record,
additional affidavit.
we'll not say
Yes.
anything, or we will not make any comments on that. We may record your submission.
Yes,
as a-
Lordship, that's
but,
why I need one on Monday. I will file the affidavit, or tomorrow we'll file the affidavit. Let the matter come up on Monday.
Then we'll issue notice. You issue notice and you file your affidavit, take your time. There is no urgency, no interim order.
No interim order. Then fine, Lordship.
my lord, may I make small submission? My lord, what my learned friend has said, I do not know. What we have to refuse to receive, I do not know, my lord.
That is
Number
why,
one. Number
that
two.
is why, Mr. Talukdar, we have said we will not make any comments on his submission. Let it be on affidavit. You have to be given a fair chance. It will be given.
My lord.
But your experience, our experience in giving a fair chance has not shown much result. You have not even dealt with the primary submission, which all along you are making that there is no notice.
My lord,
Heard.
I have mentioned here, my lord, and what they have done, my lord, yesterday, my lord, it has a CCTV footage, my lord. I can produce before your lordship. Nothing is like this. What my lord
Let the affidavit be filed. We are not saying anything. on this
Then, my lord, I may be protected, my lord, till then, my lord. Otherwise, my lord, even my lord, the pending proposal is not yet been, my lord, it is admitted that there is a proposal, my lord. Report is there, my lord. This is to be disposed of, my lord, before proceeding anything, my lord.
Heard Sri A.K. Talukdar, learned counsel for the petitioners. Also heard Sri D. Saikya, learned Advocate General, assisted by Sri D. Nath, learned senior advocate. Full stop. This matter was moved on 16/6/2025 by seeking special permission, and an order of status quo was passed till the next date fixed, which was on 17/6/2025. Full stop. On 17/6/2025, the learned Advocate General had contended that the entire foundation of the writ petition, that no notice was served, was incorrect, and he had in fact placed on record a copy of the notice. Full stop. However, in the interest of justice, an affidavit was directed to be filed, which was accordingly done, and the matter was taken up again on 19/6/2025. Full stop. On the said date, the learned counsel for the petitioners had submitted that he would file a rejoinder affidavit during the course of the day, and considering the urgency expressed, the matter has been fixed today, and the order of status quo was directed to be maintained till such listing. Para? Sri Talukdar, please have your seat. The learned counsel for the petitioners has submitted that the petitioner number 1 is having a tea cum rice shop, whereas the petition number 2 is running a pharmacy. Full stop. It is submitted that the land in question is under possession since the year 1997, and the holding tax have been regularly paid to the Dhubri Municipal Board. Is it board? Board. Full stop. It is also the case of the petitioners that they had applied for settlement of the land in question, and a report was issued on 7/11/2009. Full stop. However, the said proceeding was not brought to a logical conclusion and is still pending according to the petitioners. The learned counsel has also drawn the attention of this court to a certificate dated 5/3/2011 regarding the possession. Full stop. He has also highlighted that the drug license and trade license, trade license and drug license, which were earlier issued, have been renewed from time to time, and there is also electricity connection. Full stop. Under that aspect, the eviction proceeding is wholly unauthorized. Full stop. It is also the contention of the petitioner that unless the earlier process by which the settlement of the land was sought for is brought to a logical conclusion, the present eviction proceeding would be wholly unauthorized and without jurisdiction. Para? He has highlighted that till date there is no order of any rejection of the earlier proposal. Full stop. As regards the aspect of notice, the learned counsel has submitted that the same was not served. Full stop. Para? Per contra, Sri D. Saikya, the learned AG, has submitted that the notice was indeed served, a copy of which was placed before the court during the consideration of this case on 76/2025. Full stop. By referring to the affidavit in opposition filed by the respondents 2 and 3, he has on 18/6/2025, he has submitted that so far as the earlier proposal is concerned, the same was not accepted by the Subdivisional Land Advisory Committee, as the proposal did not qualify for settlement. Full stop. He has referred to the averments made in paragraph 6, paragraph 6 of the affidavit in opposition, as per which the scheduled land falls within the reservation of waterside area that is 25 meters from the river. Full stop. For ready reference, the averments made in paragraph 6 is extracted here in below. Para. With regard to the regard to the issuance of notice under Rule 18 of the settlement rules, the averments made in paragraph 10 of the said affidavit has been pressed into service, which read as follows. Paragraph 10, page 48. Additionally, the learned AG has also contended that as per written instructions, the conduct of the petitioners is such that they are not entitled to any equitable relief. He has submitted that when the notice involved was sought to be served on 14th and 15th, the establishments were found to be closed. Full stop. Further attempt was made to serve notice on 7/6/2025, and while the petitioners had refused to accept the notice, the process server was put to captive and was ultimately released on arrival of the police. And under such situation, the notice was pasted on the premises.
My lord, on this point, my small submission may kindly be recorded.
We have not accepted, Mr. Talukdar. Have you accepted?
Actually incorrect, my lord. We have video footage, my lord.
The aforesaid averments have, however, been refuted by Sri Talukdar. Para. Though this court let notice be issued returnable by 6 weeks. Sri D. Nath, learned senior government advocate assisting the AG, accepts notice on behalf of all the respondents. Para. As regards the interim prayer, the consideration on which the earlier order of status quo was granted was the aspect that notice was not served. Full stop. The affidavit in opposition filed on 18/6/2025, more specifically, paragraph 10 thereof, has categorically dealt the aspect of service of notice. Full stop. Though the petitioners have filed a rejoinder affidavit, it is a matter of surprise that the said averments have not even been dealt with, not to talk of any denial. Full stop. In that view of the matter, this court is not inclined to pass any interim order. Para. The state respondents may file additional affidavit to bring on record the subsequent developments, which the petitioners would be at liberty to refute if so advised.
My lord, my humble submission is that, my lord, even the Supreme Court, your lordship, that the 15, at least, even if the notice is, your lordship is concerned, my lord, then, my lord, it is still to be 15 days, my lord.
The rejection of the interim prayer is also on the basis that overwhelming public interest should give way, that private interest should give way to overwhelming public interest.
Deeply obliged.
My lord, at least,
Yes,
my lord, 15 days time should be given, my lord. This is Supreme Court judgment. This
You apply to them.
My lord, DB judgment, division judgment. Also
You apply to them, they will consider.
My lord, 15
You
days.
apply to them.
My lord, if do not give us demolish today, my lord, how can we, my lord?
You apply.
My lord, kindly give this 15 days time notice, my lord. They have passed 15
If
days.
you want to make such a submission, this should have been the first submission, not after half an hour. We have wasted half an hour
My lord,
before
I
his
thought that your
submission.
lordship will
Sorry.
hear, my lord, on my
Yes, next.
pending proposal, my lord.
Next.
But if it is not, kindly give us 15 days notice at least, my lord.
We have passed orders. Yes,
Like
next.
that.
64, item 64.
Yes. Why don't you acquire the land, acquire it?
Lordship. Lordship,
If
in fact,
there's an earlier order, you cannot violate the earlier order.
yes, I have.
See,
in fact,
your action is because of public interest, water logging is there, you want a drain.
Exactly.
But do it in the manner prescribed. You cannot just force.
Lordship, in fact, Lordship, so far as the instruction is concerned, Lordship, the authority went there subsequent to the order dated 15/6/2025, Lordship, annexure 1 of my instruction. That is also part of the writ petition.
Then?
At that point of time, Lordship, it was not known to us about any court order.
Okay.
It was in the, before the premises, Lordship, one lady come out, Lordship, and she handed over. a
Now
copy.
you're aware of the court's order.
Yes.
Acquire the land, invoke your urgency clause.
Yes.
That may be a.
Latest judgment is probably not within the knowledge of my
No, we'll issue notice at this stage. We'll protect you because of the earlier order. But there will be no restriction for you to take in action.
Petition is entirely different.
First, we SP Royal Learned Counsel for the petitioners. Para. It is the case of the petitioners that they are running a 10+2 CBSE affiliated school in the name and style, inverted comma, Hindustani Kendriya Vidyalaya in the Pataland of the petition number 1. Full stop. The case projected is that on an earlier occasion, there was an attempt by the PWD to dig a drain in the patta land of the petitioner, which was, however, the subject matter of challenge in an earlier writ proceeding, being WPC 2694 of 2018, in which this court had passed an order dated 25/9/2023, by which the petition was allowed. Full stop. However, this court had made an observation that such process can be done only after acquiring the land in question. Full stop. It is the case of the petitioner that without taking resort of any acquisition proceeding, on 15/6/2025, a similar action was thought to be done, for which the petitioner has been forced to approach this court again. Para? 3. P. Nayak, Learned Training Council, PWD, GMC, has however contended that the earlier order of this court, which was passed on 25/9/2023, was not within the knowledge of the concerned officer. Full stop. Para. Let notice be issued, returnable by 6 weeks. Sri Nayak, the Learned Training Council, accepts notice. No, this revenue is there. No, this is only District Disaster Management Authority. District Disaster
Authority under the Act 2005.
I think you can, Nayak can take, I think.
I can.
For 1, 2, 3, 4.
All I can.
For all the respondents. Let extra copies be served upon him by Monday, within 2 working days. Para. Heard the Learned Council on the interim rare. Para. This court in the earlier judgment dated so has clearly interfered with the action to make any changes in the patta land of the petitioner without following the due process of law. Full stop. It is seen that till now, no process for acquiring the land in question has been initiated. Full stop. In view of the above, comma, Status quo as on today is directed to be maintained till the next date fixed. Para. However, considering the public interest involved, comma, there is no restriction for the authorities to initiate a process of acquisition, which however has to be done strictly in accordance with law.
Oblige. Oblige.
65.
Give extra copies to him, madam. 60.
May I please, your lordship? Lordship, here the petitioner coming before your lordship for the illegal eviction, my lord. What happened, my lord? The petitioner was occupying a plot of land of 11 lessers, which belongs to the Durham Municipality Board, my lord. And that plot has have 6 bighas of land. Out of 6 bighas of land, 11 bighas has been allotted to me by giving the NOC.
Out of 6, 11 how?
Out of 6 bigha, my lord.
11
lessers was
11 lecha.
11 lessers was given to me, my lord.
Okay.
By issuing the NOC, my lord. By taking the decision in the general meeting of the Durham Municipality Board. But at present, my lord, what happened, my lord? Part of this month, my lord, the board has taken a decision cancelling the earlier decision, and immediately within an hour, my lord, I have been evicted, my lord. In the meantime, my lord, the district authority has conducted an inquiry, my lord. In the inquiry, my lord, I have been asked to appear before the authority on 4th of this month. But 3rd of this month, my lord, the Durham Municipality Board has taken the decision without any reason, without anything, my lord. No notice has been served, without giving any opportunity to protect my household articles, my lord. Immediately, my house has been demolished. Kindly turn to page 18, my lord.
Lordship, as per my instruction, Lordship, there is no such NOC in the official record of the Durham Municipal Board. And
we issue notice at this stage. Demolition has already been done.
Lordship, no interim order. Lordship.
Demolition has already been done. Where is the interim order?
No, my lord, my prayer is that, my lord, they may be restrained to utilize this land for during the pendency of this case. My lord,
They can utilize. Do not create third-party rights over this land.
Yes. Yes.
Heard Sri D. Barwa, learned counsel for the petitioner, who is aggrieved by the process of eviction and demolition of the house of the petitioner.
Yes.
Full stop. It is the case of the petitioner that the land in question was duly allotted to him by the Jorhat Municipal Board.
Wait, please, your lordship. My submission is that the land was not allotted to him.
No, my lord, she is.
Was duly allotted. We have not passed allotted to him by issuance of an NOC. Full stop. Para. Per contra, Ms. R. Deka, learned counsel for the Jorhat Municipal Board, has submitted that as per instructions, comma, no NOC exists in the records, and therefore the eviction and demolition has been done in a proper manner.
And no agreement was executed.
She has also highlighted the aspect that there was no lease agreement with the petitioner. Para, let notice be issued, returnable by 6 weeks. Urban UDD, SS Roy, State Council 1, 4 and 5. Madam, for all 2, 3 and
3 and 6.
2, 3 and 6. Extra copies by 2 working days. Sri Borwa, the learned counsel, prays for an interim order. Para. However, considering the fact that the demolition has already taken place, comma, no blanket interim order can be passed. Full stop. Nevertheless, to balance the equities, it is directed that till the next date fixed, no third-party rights may be created. Be created in the over the subject land. Yes.
Madam, may I one point maybe point out, my lord? She has submitted. My lord, there is no agreement, no NOC. My lord, in the page 25, my lord, as per the minors, my lord, it was clearly stated that that has been decided to give the land to the petitioner, and I have annexed the NOC as
Let them file
I will disclose everything.
Let them file affidavit. Yes. Next.
My lord, that is given.
6 weeks. Mr. Kumar?
Well, the petitioner is the owner of a coke factory in the state of Arunachal. Now, to go to that industry, to go to that factory, and he has to go through a reserve forest area. And there is a road going through that reserve forest area. The Gambura has given a certificate that this road is in existence for last more than 100 years. So far, my
This
lord,
road is in the state of Assam.
yes, it goes through connecting to the forest area of Arunachal Pradesh, my lord.
No, this area, the road is in Assam.
In Assam, and that is the only road to go to that place.
Thereafter, what is
But
that?
what is initially, my lord, the private response, we have made these officers by name party. They demanded money from us. We did not give them. Then first, what they do, they go to our plant in Arunachal and seize our excavators and other machineries from there, which they can't do in the state of Arunachal. Second, my lord, when one of our Bolero Jeep pickup truck was going carrying diesel, urea, and all those things, that was seized. Thirdly, my lord, they even went to our residence, this forest officials, they went to our residence, did a charge, seized cash money, which they have seized around.
Yes, Mr. Gogol.
Malala, kindly come to page 79.
79.
79.
Yes.
And this goes to show that the owner is somebody different, some different, my lord. Mansem Launching is the owner of that so-called purported coke plant. Secondly, my lord, will come to page 143. This area, of course,
From where do you get
page 79, my lord. It is informed that examining the Mr. of it is found is nothing to do.
No, where are you reading? 79?
79, my lord. During the course of inquiry, it is submitted by the OC, my lord.
During the
Seized by
course, it
Assam
is
police.
learned from one so excavator. has
Yes,
been
my lord.
Seized by Assam Forest from the position of Kushal Singh of so.
This is only an intimation.
Further, it is informed that examining and hearing the complaint and Mr. Manchan launching of Twin Bureau PO PS Panma, it is found that he has nothing to do in this matter because all JCB's dumpers belong to Mr. Kushal Singh. So he has placed the complaint only being instigated by Mr. Kushal Singh since the matter is disputed between Assam Forest Department and Kushal Singh.
No, the coke belongs to whom?
But your lordship will see the documents from page 80. Next page.
80.
80. This is the lease agreement between the first party and the second party is Kushal Singh, me.
Page 87.
Then your lordship will see at page 87 the trade license. This is the issued by the additional DC Jairampur. Then your lordship will see page 94.
Exactly, madam.
This is the of Geology and Mining Department. Then your lordship will see
This
96.
Now, page 87 is in whose name?
But just a moment.
87, trade license.
Trade license is additional deputy commissioner.
Whose name? Whose name?
Yes, madam. Just a moment.
Yeah, 890, madam. Oman Yantho Langching, page 90.
Yes.
Okay.
With which you have the
Trade license is in the name, but there is an agreement.
Interlancing is the which
No, Mr. Gogoi.
My lord, page 90.
You may be correct in contending, but he is directly connected. He's the lease. There is a lease agreement.
Yes.
No, lease, my lord, will kindly see the content of the lease.
Yes.
Lease is content of lease, my lord. Page 83.
Yes.
5.
Yes.
It's a lease of 2019.
Yes.
And the concerning page is page 95.
Yes.
So owner is totally different. And this says something else. 83 says he is allowed to install so and so.
Yes.
If in 2018 it already existed,
Yes.
what is the point of entering into a lease in 2019 saying that he is permitted to so and so?
No, that
My
can
lord,
be- that
Omar
can be-
Siento Lansing
that
is
can
the
be-
son of Wazo.
Those matters we can
Yes.
take care of. But see, he has a right to approach the court.
Yes, my lord, kindly he is.
Will issue notice at this
My
stage.
lord, the only thing is that since they are harassing me and even they have
Take instruction.
you will not, my lord,
lord,
your lordship
since
will
being part
direct
is
them
being-
not to take any coercive action without the leave of this court, my lord. No confiscation order till that,
No,
why not?
no,
If your actions are illegal, your
No,
officers, you
Mr.
are not here defending the officers who have demanded money
No,
from us.
Mr. Kaur,
Yes,
if
ma'am.
we can pass an interim order saying that no coercive action without following the due process of law.
Yes.
No, not blanket stay order.
Yes, yes, madam, why
No,
not?
madam.
That's the,
You follow the law.
They have plans.
your lordship will see
Mr.
page
Gogoi, you
141.
follow
Will follow the law, man, because falsification
Third,
notice has been issued, man.
the court learned senior counsel for the petitioner assisted by H. Agarwal.
Yes.
First up, as per the facts projected, comma, the petitioner is is running a coke industry in the Changlang district, Arunachal Pradesh, and the access to the site is through a road which passes through the Tinshukia district,
Lekhapani Reserve Forest.
through the Lekhapani Reserve Forest in the district of Tinshukia.
My lord.
Full stop. The petitioner, the learned senior counsel has submitted that the respondent numbers 10 and 11, who have been made parties by name, have been harassing the petitioners by illegal demands pertaining to their transportation. Full stop. Para 3. D. Gogoi, learned standing counsel, Forest Department, has however submitted that the documents annexed may not be sufficient to establish that the petitioner is the owner of the coke industry in question.
Also, another content.
He has also submitted.
It's reserved. It's in Assam, my lord. The 143 page number.
He has also submitted that the lease agreement pertains to a period which may not come to the support of the petitioners. Para, let notice be issued, returnable by 6 weeks. 3. Gogoi, learned standing counsel accepts notice on behalf of
1 to 4.
1, 2, 3, 4.
5, 6, 7 will be the 5 and 6 will be the state of Assam.
Not 8.
Not 8. 7 is also Arunachal.
5, no. First Gogoi. Yes, Gogoi. 1, 2, 3, 4.
4, my lord.
5 and 6 is 5, not 7.
7 is Changla.
5 and 6 SS Roy. 7 Chandan, 8 Chandan, 7.
8, 9.
7, 8, 9.
10 and 11 by registered.
10 and 11 by registered post. Para. 3. Quad Ilanus Senate Council prays for an interim order. Post up para. It is till the next date fixed. And it is needless to state that no coercive action be taken, is permitted to be taken without following the due process of law.
Against.
Well, 6 weeks we have made returnable.
The Lord may give any fixed date after 6 weeks. I will take
Tell
it
us,
from the court.
tell us.
We'll take from the court.
No, we give as requested list on.
My lord, let it be 4 weeks because this area is under Dihing Parkai. There's a petition pending, my lord. We are facing
On 16th.
16, my lord.
16 July.
16 July, my lord.
Yes.
Obliged,
लिखिए. Heard the learned counsel for the parties who have appeared online. Full stop. By this IA, a correction has been sought in respect of the judgment dated 23/5/2025 passed in WPC 619/2024. Full stop. It has been pointed out that in paragraph 28 of the said judgment, comma, the interference with the impugned order has been recorded. Full stop. However, the date of the impugned order has been recorded as 28/10/2024, which should have been 2/8/2024. Para. The records have been perused, and it indeed appears that the impugned order is dated 2/8/2024, and the recording of the date as 28/10/2024 is due to inadvertence. Para. In view of the above, the I stands allowed by observing that the impugned order, that the date of the impugned order in paragraph 28 of the judgment dated 23/5/2025 should be 2/8/2024 and not 28/10/2024. Para. Let this order be read as a part of the judgment dated 23/5/2025. Para. I accordingly stand allowed. খবৰ দি দিব খবৰ দি দিলে হ'ল এলাউ আৰু এডভোকেটৰ যে নাম আছে নামবিলাক দি দিব কমি লিখি ওকে য়েছ
Item 9. Item 9.
কোন আছিলে বি ফুকন বি ফুকন য়েছ
Yes, may I please, Your Lordship? Sealing an eviction notice. This petition is filed, Lordship.
9.
Oh, 9. Oh, 9. Somewhere.
Yes.
Earlier petitioner has been approached before this honorable court by challenging a notice issued against her for evicting.
Yes, have you passed this making order?
Lordship, my lord, that in person to the my lord, that order. Lordship, that instruction I have to take.
Yes. What is this instruction?
So, my lord, that notice has been served, duly, my lord, heard the petitioner, and after that, my lord, this eviction notice has been.
You can challenge this order. How can you maintain this petition without challenging the order?
No order has been served to me.
You have to obtain the orders.
I have not received any order. Lordship, after 9/4/2025.
It has been received by you. There's your signature.
9/4/2005, my order was passed.
No, you had appeared. Yeah, can you show him the order sheet?
7/4.
7/4, and the petitioner appeared.
And he was asked to, my lord, she was asked to submit a legal document, my lord, that they could not be, my lord, produced.
It was prior to the disposal of writ petition.
Yes.
That is why I was confusing that after 9/4 she was not called for. Then also I have to receive a order.
No, you're present. If you want an order, you should apply for it. You are present, you are heard, your signature appears on the body of the order itself. Where is the earlier order?
Earlier order is at page.
You file an affidavit.
Lordship,
We'll issue a short notice.
Lordship.
Okay. Heard Sri B. Fukan, learned counsel for the petitioner who is aggrieved by an eviction notice dated 5/6/2025 issued by the circle officer, Guwahati Revenue Circle, whereby the petitioner has been directed to vacate the premises by 13/6/2025. Full stop. It is the case of the petitioner that the petitioner had approached this court earlier by filing WPC 1311 of 2025, which was disposed of by the order dated 9/4/2025 by directing that no eviction should be done without following the due process of law. Para. Where is that order 9/4?
9/4 at page number. Page 32. Okay.
Operative portion.
Operative portion is at 35, paragraph 6. 35, paragraph 6.
But while this order was passed at the motion stage or what?
Lordship.
Motion stage.
It's
So,
admission.
oh,
Admission.
did you bring to the notice of this court the proceedings of 7/4?
I do not know.
My lord, that notice 7/4 was.
Has it
not
been
there.
mentioned
My lord, it is
anywhere?
the- I think, my lord, it is because of an admission.
Admission is.
No, but was the proceeding of 7/4 brought to the notice of the court? No.
No, lordship, no. That's why, my lord, this order was.
Yes. Then where is the order? Where is the scope to pass any further orders?
This, sir, it is there.
We cannot pass an interim order. We can issue notice at best. Okay. What did we say? Huh? What did we say last? Due process law. Tara. Let notice be issued returnable by 6 weeks. Revenue, Madam Ms. G. Hazarika, then Standing Council Revenue accepts notice on behalf of Response number 1. Whereas 3, J. Hendrick, Learned State Council accepts notice on behalf of Response 2 and 3. Extra copies be served within 2 working days. Para. Sri Fukan, the Learned Council prays for an interim order. Para. On the other hand, comma, Sri J. Hendrick, the Learned State Council has submitted that written instructions along with the relevant documents have been obtained by him pursuant to the order dated 13/6/2025 passed by this court. Full stop. He has submitted that a proper hearing was done in which the petitioner had participated. Full stop. Thereafter, on 2025, the eviction notice was issued, which was received, which was served, which was acknowledged, which was served in presence of two witnesses, including the daughter of the petitioner. Full stop. The same was followed by the notice for eviction on 5/6/2025. Full stop. Since the notice prima facie appears to be in order, comma, this court is not inclined to pass any interim order. Yes. The documents handed over by Sri Jehandik, London State Council, are made part of the records.
Item 36.
Object.
36 also is also your case.
Yes, Lordship.
Yes, madam.
Lordship, Lordship, in this case, a settlement was arrived between the parties. The petitioner is misunderstand that he has to pay 8,50,000 as due. But when the court asked any fair settlement, they said that they have received 11,50,000. So in Annexure A, Lordship, kindly go to Annexure A, page 10. There is a settlement of 66 lakhs.
How much?
66.
66 lakhs.
66 lakhs,
Okay.
out of which 55 lakhs has been paid.
Okay.
Okay, 66 lakhs in two columns. One is for Sonno Soikia, it is his personal loan, who is not the petitioner. But they calculated together. Therefore, they said that they have to entitle 11,50,000.
Okay.
In such circumstances, the petitioner is ready to pay the amount, but he needs 3 months' time only.
Madam,
Lordship, the settlement is already paid. They didn't pay the outstanding amount,
how much was the settlement?
66 lakhs, which is already paid because they.
Yeah, he
paid
said he
for
paid
pay-
55 lakhs or something.
No, 66 lakhs.
How much has he
as per
paid?
The annexure,
How much has he paid?
55 lakhs.
55. Yes, it's
Yes,
not totally failed.
8,50,000 is pending, but they are failed to pay this amount.
How much is pending? 8 lakh?
8,50,000 is pending, but the settlement is paid.
Oh.
So as per today, 11,60,000 is pending, and we already informed
11 lakh?
11,60,000,
Yes.
which is outstanding.
Yes, still, in how much time can you repay this?
Within 3 months out.
They can approach the bank directly. I have no instruction about this.
What do you do?
I file an application before the bank.
What do you do? Who are you?
I'm the Dinko service.
What is your business?
Business is a water bottling.
Water bottling. Where?
Nagaon.
Nagaon. Business is running.
Business
Okay.
is now running.
Okay. In what time, in how much time can you arrange this 11 lakhs, 60,000? 3 months is too much.
Liquid. Business is not so smoothly running.
How much? 2 months time? 2 months time. Madam?
I need to take the instruction.
No, is there any coercive action against you?
No interim. Interim order is passed.
There.
What interim order?
No coercive action until further order.
No coercive action. Okay.
They can approach the bank directly.
We'll do one thing. Heard Sri B. Fukan, learned counsel for the petitioner, as well as Miss M. D, learned counsel for the respondent bank. Full stop para. It transpires that the parties had entered into a settlement for payment of rupees 66 at an amount of rupees 66 lakhs. Full stop. However, the petitioner could not pay the entire amount and only entire amount, and an amount of 55 lakhs
55 lakhs
has been paid in the meantime. Full stop. Para. Ms. Day, the learned counsel for the bank, has submitted that on account of the failure on the part of the petitioner to pay the entire amount within the stipulated time, the settlement has failed. Para. Sri Fukan, the learned counsel for the petitioner, has however submitted that the balance amount of 11,60,000 would be paid by his client within a period of 3 months from today. Para. Considering the facts and circumstances and balancing the equities, this court grants 2 months' time to the petitioner to clear the balance amount. Full stop. Let this matter be listed after 2 months, during which no coercive action be taken by the bank. Full stop. The aforesaid direction, would, however, be reconsidered, or would, however, be reviewed on the next date.
Right.
22.
It is your lordship. My lord, perhaps mistakenly this matter is listed in the impediment for parties plan lordship.
IA for?
IA is for passing an interim order for lordship. Lordship, without considering this aspect, your lordship may hear the entire matter.
Lordship,
Because my learned friend
here we
also.
are filing, if it, your lordship, we have sent it for betting, your lordship.
In the main writ petition.
Lordship.
Okay. Heard Sri N.H. Borbhia, learned counsel for the applicant, as well as Sri R. Boro,
Sir.
learned counsel representing the NHI.
NHA as well as NHA DCL.
NHI DCL. Para.
5, 6, and 7.
The learned counsel for the parties have, however, informed that though this IA has been listed under the column impediment of parties, the same was actually for passing an interim order. Full stop. Nonetheless, be that as it may, Sri Borbhia, the learned counsel for the petitioner has submitted that the entire writ petition can be taken up for consideration. Para. Sri Boro, the learned counsel for the respondents, has submitted that the affidavit in opposition has been prepared and sent for waiting, and he accordingly prays for some time. Para. List this case for admission hearing
Not wait me.
on 31st of July 2025, by which time the affidavit may be filed.
Obliged.
23. IA for impediment
My lord.
in contempt
That's
matter.
number 3, my lord. Yes, my lord. In the meantime, my lord, the district commission has changed, my lord. That's why, my lord.
You want to implead
Yes,
the
sir.
new district commissioner?
Yes.
Where is the notice? Raman, where
My
is the
lord.
notice?
Complete.
Where is the notice?
Notice, no notice, my lord.
How can you implead in a contempt petition without a notice? He has to be made aware of the fact that there is an order pending which needs implementation. You don't file implement application without a notice.
My lord,
Issue notice will keep this pending. Issue notice immediately.
my lord, my learned friend has already appeared for a respondent.
No, I didn't appear to my lord, the overall court
It
had.
is not a question of appearing. It is a question of impleadment of a party in a contempt petition. Can you implead a party without issuing notice to him?
My lord,
Issue notice, we'll keep this pending. Don't
Yes.
file like this.
Yes.
Issue notice, give him time. If he doesn't comply, then come. Okay. Though I heard Sri W. Raman, Learned Counsel, who has filed this application for impleadment of new incumbent. Full stop. It, however, appears that no prior notice has been issued to the.
my lord, in the contempt petition notice was issued to the respondent number 2, my lord.
Please understand. It's not the notice issued by the court, it is the notice to be issued by the party or his counsel. You have to apprise that this is an order you have to comply with. Give him time.
Notice
Uh,
this order to comply করিব
to the new incumbent who has been sought to be impleaded. Para. In the interest of justice, the I is adjourned by 6 weeks, and in the meantime, the petitioner is required to serve notice upon the party who is sought to be impleaded and file proof of such service by means of an affidavit. Para. List after 6 weeks.
Lovely.
Have you understood?
Well.
Yes. Item 24. Yes. Sudhakar?
But I have received the instruction letter, but
What is the urgency here?
well, the lordship has picked the matter for instruction and kept it for consideration of the interim order. Well, my instruction frankly, similar the apprehension of the petitioner is that his land has been requisitioned. And
You have the instruction, you file your affidavit.
well, the only difficulty that lordship has on last occasion said in the last order, I did take up last order.
11-6.
11-6,
Yes.
second paragraph.
Hmm.
The honorable court has said, however, till the next date of listing, that is 26,
Yes, we have seen that.
Lordship, at this stage, we have started the joint survey and to assess the Jirat building structure standing over the requisition land.
Yes.
The instruction paragraph 9, kindly see, I'm reading that paragraph 9. The land acquisition
What is
estimate.
this form C?
Form C, that page 17.
28-5, what is this 28-5-25 order? 28, how can it be 28? 28-5, okay. Where is it?
28-5, that page
Page
70.
70.
Page 70.
What is it?
It is similar the under section 4.1 of the 64 Act, this was issued. Whereas the land described below has been requisitioned under section 3.1. 3.1 is previous prior to that it is an act of the land acquisition land requisition and acquisition act 1964. You being the owner, tenant, person in occupation of the state land are directed to surrender or deliver possession of the requisition land to the collector of metropolitan within 15 days from the date of this. The serial number 46 is the petitioner here.
Yes.
The lordship has directed not to give effect to this particular form till today.
Yes.
But what the authorities are doing, now the process of joint survey is going on to assess the Jirat land valuation and the building structure valuation. But my respectful submission is that they have also stated that after this evaluation, they will send the entire proposal to the estimate to the acquiring authority, and then the 6-month notification will be issued for acquisition of the land. So, petition of the petitioner will not be disturbed till issuance of the notification on the 6th month. So, at least the valuation part.
No, what are your grounds of challenge?
My lord, my basic ground is, my lord, they've invoked the 1964 Act, my lord, and they've issued a notice of requisition. The rule cited is the rule for requisition, my lord. However, it appears from the notice that it's a acquisition for apparently setting up an grid station, my lord. Now, under the garb of requisition, they know from day one that they'll eventually have to acquire it, my lord. But they're issuing a notice under section 3 so that they can take over possession, which is apparent from form C, my lord. So which is why we are saying that this will bypass the entire act of 2013, my lord. Because under the 2013 Act, your lordship knows that.
No, Mr. Decker,
My lord.
your benefits
My lord.
or the compensation aspect
Right.
cannot be less favorable than any existing act, which is the best act.
Yes, yes.
That is the law.
Yes, yes.
There is a notification of the Department of Revenue.
Yes.
That if any an action or for that matter acquisition is done under 1964 Act, but the compensation will be paid under 2013.
That is the law.
That's all right, my lord.
That is all.
My lord, let them fi- let
Okay,
them
well,
fi-
we'll record your submission.
Matlab, my submission may be recorded and matlab, the process of.
We'll have this after 1 month.
Matlab,
Till then, what is the development? You let us know.
And matlab, the process which is going on for.
Don't disturb their possession.
Yes, survey can go on, my lord.
Possession will not be disturbed.
Okay.
Lordship, after the joint survey will go on.
Okay. For the BD Decker Learned Counsel for the petitioner, who by referring to the order dated 11/6/2025 had submitted that while issuing notice, an interim order was passed. Full stop. Para. 3. D. Nath Learned Senior Advocate Assam has submitted that written instructions have been received in the meantime, as per which, the land in question would be ultimately acquired for public purpose. He has also submitted that the process for such acquisition would take some time, which has to be preceded by joint survey and other assessment.
That process is going on, that may not be disturbed.
Considering the above, this court, this court directs the learned counsel, the state council to file affidavit. Full stop. The matter may accordingly be listed after 4 weeks. Full stop. It is further made clear that while there will be no restriction for carrying out a joint survey and other process for assessment, the petitioner's possession over the land in question should not be disturbed.
Obliged.
Item 25.
25 minus I'll seek some time. My senior, Mr. Goswami is appearing in this matter for the report.
1 and 2 are supposed to file affidavit.
3 has filed.
3 has
He has filed.
Who is 3?
He is the.
DGP.
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 And you are for Forest Department?
No, my lord, I appear on behalf of Mr. P. N. Goswami.
On regarding?
On, as a, on political.
What is the matter about?
My lord, the petitioner is assailing a direction by the state government, whereby, my lord, an order passed by the State Police Accountability Commission to initiate DP against the private respondent has been set aside. He has petitioner initiated a case, then the State Commission deliberated the matter and passed the order that you initiate
Proceedings.
DP process.
Thereafter,
the state government in the home and political, my lords, they issued a communication that no, this commission, you have went out of your mandate. This is not your duty, and this may be kindly reviewed. That was the order. That was the issue. That is prima facie. I have just read the file. Mr. Goswami will address the court matter.
Okay, who will file affidavit?
1 and 2 minutes.
Okay.
Ministry.
Though respondent number 3 has filed affidavit and reply affidavit has also been filed, a prayer for adjournment has been made on behalf of respondent number 1 and 2.
1, 2, and 3.
3 has also.
3 has filed 1 and 2 minutes.
1 and 2. So as to enable to file affidavit in opposition. Correct? List after 3 weeks.
3 weeks, madam.
Three weeks.
Name of Mr. P. N. Goswami may be detected.
Name of Sri P. N. Goswami, learned AG, be reflected in the cause list.
Public.
26 to 28.
Make peace to Lordship.
Yes.
Lordship, I'd like to pray for some time to file our affidavit. Lordship in 3.
What is this, Mr. Dasgupta?
No, this is a matter for eviction under Rule 18 by the Karbi Alang District Authority, below. Now, this court has an occasion to pass an order whereby the district concerned authority was.
You are protected by an interim order.
Yeah. Now, one thing, below, this court passed an order whereby the respondent authority was directed to consider our case whether we are holding the Pakka land or not. In the morning session, I had a discussion with Jayanto, and he told me the inquiry is at the verge of the conclusion. So I told all that the matter be listed after vacation. That was our understanding. I don't know what is our discussion. Probably it is.
Yeah. No, I'm
Hello.
praying time to file affidavit.
Heard Sri A. Dasgupta, learned senior counsel for the petitioners. Para. Miss so-and-so learned counsel appearing for the understanding counsel KAC
Yes.
has, however, prayed for some time to file the affidavit in opposition. Para. List after 4 weeks. Para. Interim order passed earlier to continue till the next date of listing.
Item 30.
Mr. Mazumdar?
Yes, your lordship. Here, your lordship. The petitioner was agreed to allot 5 numbers of shop, each measuring 100 square feet, your lordship.
Where?
Yeah, at Sabua Municipal Commercial Market Complex, duplicate. Then subsequently to filing of the writ petition, the respondent have filed an affidavit. They assured to give immediately then 3 shops at the ground floor and remaining 2, they assured to that shall be provided in the first floor. In the meantime, your lordship, 3 and another 1, 4 shop has already been allotted. 1 shop has remained here. This is the.
In the meantime,
Are you pressing with the petition?
Yes, your lord.
Pressing still. 4 have been given.
4 is 100 square feet. Earlier, we are in position of 586 square feet of.
Mr. Mazumdar, your band is in a very precarious position.
Sorry, your lordship.
No, it doesn't matter. Anytime something may happen.
Yeah. It is highly.
No, forget it.
No. It is, I have to maintain my decorum. Sorry. Yeah. Now, already 4 shop has been allotted.
Yes, you want 5 shops.
5 shop. Even they have agreed. Their affidavit, your lordship, in page 4. May I read, your lordship? That second paragraph, that.
Affidavit filed.
Yes.
What do you propose, Mr.?
Allotted 3 number of shops.
Lordship.
No. What do you propose regarding 5, claim for 5?
Lordship, because when they are holding the shop, it was in a dilapidated condition. Now
Yes,
it is
old
being
complex.
old complex. Now RCC building has been.
No, that we have understood. We are not on the circumstances. Are you willing to allot 5 shops to the petitioners?
Lordship, we have managed all lordship, so
It is in their affidavit, your lordship. They have already allotted and may I read, your lordship, that the so far the instant petition is concerned, the Sabua Municipal Board has allotted the petition 3 number of top at serial number 46.
No, that you have already submitted.
51. Subsequently, another shop.
Now, what is your claim now? Are you
And shall allot the 2 at the first floor. In the meantime, they have already allotted another shop. Now the petition has expired and the legal has been substituted.
How can we have this matter after the vacation?
yes.
Is there?
No.
Okay. Heard Sri R. Mazumdar, learned counsel for the petitioners.
Yes.
As well as Sri S. Roy, the learned state counsel. Full stop. The learned counsel for the parties have informed that there are certain developments which have culminated in allotment of 4 numbers of shops to the petitioners. and the process is still on. Para. In view of the above, the matter is adjourned to be listed in the first week of August 2025, by which time further development, if any, be apprised.
Look,
And
Yes.
And they may, penalty, they may process if necessary.
It's already on.
33.
Lottery matter, in fact, the contextual matter of the 14 months duration period is there, work is completed.
Mr. Doctor, as Doctor,
Last,
with the
last probably 2 occasion or 1 occasion they have not appeared.
none appears for the petitioner on call, whereas Sri K. Gogoi, learned CGC, is present. Full stop. On the last occasion also, i.e. 26/2/2024, there was no representation on behalf of the petitioner, and the submission of Sri Gogoi was recorded that the work in question was almost completed. Para, as a last chance, the matter is adjourned to enable the petitioner to make representation. List. Kaile khulane bondo. A list on Monday. If they are not interested, we'll close this. Date Monday ka date.
May it please your lordship. My lord, matter relates to my lord land license fees. In fact, railway, what has happened, your lordship, for manufacturing, my lord, sleepers, which is used in building tracks, your lordship, railway allots, my lord, land to the manufacturer in their campus, so that my lord, carriage and loading and unloading, my lord, it may be easier, your lordship. Initially, my lord, in 1980s, my lord, railway, they were not taking, my lord, license fees, my lord. Subsequently, my lord, they started taking license fee. In item number 34, my factory was established way back in 1989. We entered into an agreement with railway, general manager, railway, for establishing, my lord, factory. And time to time, my lord, they order us that we need such quantity of, my lord, sleepers. Accordingly, we manufacture that quantity and we enter into an agreement of. What has happened, my lord? Similar issue came up before this honorable court.
Now, what is your grievance now?
My grievance is this: the impugn notice they have issued. It is not in accordance of
Notice for
my lord, these license fees for land. It is not in accordance with 2005 notification. The same question came up before honorable court, my lord, in case of Daya engineering.
Yes, madam. What do you say? Okay, we can have this matter heard.
Maintainability. That I will apply.
Then we will have this matter for admission hearing immediately after the vacation.
Date may continue.
Okay. The Hearts Free A. Goyal Learned Counsel for the petitioners, A order, as well as Ms. B. Sharma, Learned CGC. It is submitted that pleadings are complete and the matters can be taken up for final disposal at the admission stage itself. Para. List for admission hearing on 29th of July. Tuesday. Come prepared.
Deep your. Item number 35. Get on that side, not that paper, but they are that because my lord, it was and my lord that but don't report. They are okay.
No, there is no such.
There is no order, but as for
that is up to her.
But my lord, before the court, my yeah, before at the
We can go by the records, Mr. Goel.
but
The
now it is not
assurances given by her in front of you. Let her.
everything is now recorded. The benefit
Yes.
that
Next.
keep your
What is this, Mr. Sakya?
Relating to my lord, selling surplus land. Petitioner 10 was selling surplus, my lord, hearing to the petitioner.
Affidavit filed.
No.
Let them file affidavit. Okay. Heard. 3. S. Sakya, Learned Counsel for the petitioner. Para. On the prayer of 3. S. S. Roy, Learned State Counsel. You are for? No, no. Who is for? Of? Have you filed affidavit? However, on the prayer of as well as 3, your Pathak, B. Hazarika, Learned Counsel for response number 4. 3 weeks time, 4 weeks time is granted to file affidavit in opposition. Para. Interim order passed earlier to continue till the next date of listing. Forty-three. J. Kolita. Who's J. Kolita? None appears for the petitioner on call, whereas 3. B.J. Taluk, the learned additional senior advocate, is present. In the interest of justice, matter is adjourned to be listed after the summer vacation. 44. Yes, Mr. Mondal.
Order was
Ex gratia for?
I a public place, but it was point for path.
Yes, we want your response. Yes, why CGC is why central government is a party?
President, the entire fund is funded by government of India.
Is it? Okay, okay, okay. Third 3. M.U. Mondal, Learned Counsel for the petitioner. Para. 3. On the prayer of 3. B.J. Taluk, the learned additional senior advocate, matter is adjourned by 4 weeks to enable filing of affidavit in opposition. 3. A. Dr. Learned CGC is present. Yes, next.
Apply.
45. Yes, what is this, madam? Health Department. Health. Who is for Health Department? You are for Health, the relief, the grievances against Health Department. Earlier occasion, B. Gogoi had appeared Health Department. Where is he? Yes, your firm. High Court is a party. Why? Means? Which page? Who are you, madam? Affidavits filed. Affidavit in opposition filed by whom? Not filed. You have not responded, any one of you. Health department, most like. Can you get hold of Mr. Gogoi? Madam, wait for a while. Try to have Mr. Gogoi, B. Gogoi, or anyone from the health department. I think Gogoi only represents health department. Who else? DP Bora is there. Yes, and then Madam Bora is also there. D. Bora, Deepa Bora, Deepa Bora. A. Bora, NHM. Try to get hold of them. We'll try to. Yes, is it applicable? Pankaj Mohan? No, the principles, is it applicable? If no, on the last occasion, 13-6, when the matter was taken up, the adjournment was only for enabling you to examine the aspects of applicability of Pankaj Mohan. What is the outcome in the appeal? Admitted. We'll have this after the vacation. But examine this. If it is covered, it may be dependent on the appeal, but we cannot keep this pending. If there is a stay order, the matter would be different. Yes. Okay. Heard Sri B.D. Deka, Learned Counsel for the petitioners. Ripina, you appear as what? AG? Learned Standing Counsel, PWD. However, submits that the facts in the case of Pankaj Mohan, order to say, reported in so are distinguishable. He, however, prays for some more time to examine the aspect of the principles laid down in the said case with the present case. List on matter is adjourned to be listed on 23rd of July. Okay, on 4th of August. 4th of August.
Okay.
He has also informed that the aforesaid decision is presently under challenge in the division bench. By the next date fixed, any developments in the appeal may also be intimated.
Right.
Mr. Gogoi? Madam Saikia? Yes. Any instructions? Tuesday, Wednesday will not be, will be too crowded. Motion days. We'll have immediately after the, but address the issue. It's an important issue. No, he'll take the instruction and file affidavit. You have not filed affidavit. Matter is pending since 2024. Okay. I heard Miss A. Saikia, learned counsel for the petitioner. Full stop. Also heard Sri B. Gogoi, learned standing counsel, Health Department, who submits that full instructions are yet to be received. Full stop. He accordingly prays for and is granted time for receiving the instructions and to file affidavit in opposition. List on. We give a date. Okay, we are 21st of June, Monday. Oh. Yes, after. Learned Standing Counsel, High Court, and BJ Talukdar, learned Senior Advocate are present. G. Vishwa. Okay. 47, who is 47? JMA Chaudhary. PNRD. Panchayat. Madam Thapa, what is this? Affidavit filed. None appears for the petitioner on call, whereas the department is represented by Ms. What Thapa? P. Thapa, learned counsel, appearing on instruction of Sri S. Datta, standing counsel PNRD, who submits that affidavit. You have filed affidavit. Affidavit in opposition has been filed. In the interest of justice, matter is adjourned to be listed after the summer vacation.
Also, exponent number 2 has filed affidavit.
Who is 2? Who is 2?
Deputy Commissioner.
Okay. On the heard Sri B. Sinha, learned counsel for the petitioner, as well as Sri B.J. Talukdar, learned additional senior advocate Assam. Sri Sinha, the learned counsel, has submitted that respondent number 2 has filed affidavit in opposition, which is required to be responded by way of a rejoinder. He accordingly prays for and is granted 3 weeks' time to file such rejoinder affidavit. 49. That's one number 5. You are for 5.
Yes, but
okay. Heard Dr. B. N. Gogoi, learned counsel for the petitioner. You are for respondent number 5, and SVPP as well as SVPP does, learned counsel for respondent number 5, who submits that affidavit in opposition has been filed. Full stop. Dr. Gogoi prays for and is granted 3 weeks' time to file rejoinder affidavit. Full stop. By such time, the other respondents may also file their affidavit. Madam, you are a party here. No. Ms. G. Hadarika, learned standing counsel, Revenue Department is present. The affidavits filed be tagged with the case records. Misplaced. What is the subject matter? Madam, you are lucky that you are not in the brief. You are lucky that you were not in the brief. Otherwise, you would have also been misplaced. Only the brief has been misplaced. Yes, when can we reconstruct? On the prayer made on behalf of the petitioner, matter is adjourned to be listed after the summer vacation to reconstruct the file. Okay, next. Mr. Anand. Revenue.
It doesn't affect but so they file affidavit, they did not recognize that
You have been evicted.
evicted, but without having any
Demolition.
demolition, but without having any deed, and the affidavit they also not disputed. Now this no class to be directed them and for whether has good, but this no business issue. Well, they have followed the guidance, and I felt for that they goes to put already.
Yes.
25 lakhs has been awarded. Each of the
Huh?
that is true, but they did not cite our
Paragraph 4 of your affidavit, page 96. 97.
paragraph
No, 96 page. Where does your affidavit starts, madam?
95. There.
No, no. 95 is something else.
Item number
Not 6955, not 6955. 5259.
they said that if it be covered.
Okay, doesn't matter. Page 90, 96. Yes, paragraph
Paragraph 4.
4.
It is the record submitted by the petitioner one but right by the put it by that none of the petitioner then but not that last petition that paragraph is produced. And again they have in the record whether it have then put it put.
Have you got the
And my lord, this paragraph 1 to 15, I categorically stated I felt this one categorically stated they never asked. We never have any document them. When it not verify, no other single notice.
You have the records or not? Have you got the records? Okay. Yes, Deputy Commissioner, Mr. Handik, get the records, even if they are in the tribal belt and block, notice will have to be served.
I'll page 99. Maybe that whether.
Huh? No, it is not a question of eviction. Yes, only on that aspect. You produce the records. Okay.
So the
Sri
paragraph
J. Ahmed, learned counsel for the petitioners, has reiterated that the eviction and demolition process was not preceded by any notice. Full stop.
that has been not.
And that aspect, and there is no denial of the said aspect in the affidavit in opposition filed by the respondent number 1, para. Sri J. Handik, London State Council, is directed to produce the records.
Last to they are directed that to the last order. They will direct.
No.
Not whether
Produce the records, para. Miss P.R. Mohanto, London Standing Council Revenue is present. Yes, next.
this order covering order.
List on, yes, tell us 28. What is it? 28. Item number? What is there an interim order? Who was on the other side? Yes, government, interim order passed. Item number? 49. Interim order passed earlier to continue wilderness exit of listing. 56. Mr. For whom? We'll seek some time. Okay, after notice come for the first time. We'll file affidavit, madam.
Your question of law, madam. Your question of law. Whether they can the case amount.
Have you received the instructions? Okay. On the prayer made by Miss and Kakoti Learned Council, appearing on instruction of Sri S.C. Kyle, Learned Senior Standing Council, CGST. 3 weeks' time is granted to obtain instructions / file affidavit in opposition.
That
Okay. List on, not 14th, cannot be on reprint. List on 25th of July. Okay. If it's a question of law, you can, without even an affidavit, we can perhaps bring the instructions. Okay. Yes, Mr. Kolida.
Admitted amount of 95 where the director or file an affidavit. 7 has filed their affidavit. What they have considered the people are not for direct. They are
Who is for the 7? 7, Hadarika, you are for 7. 7 is the Deputy District Commissioner. Okay, 4 District Commissioner. What is your stand? Yes.
Page 4, paragraph 5, page 4 last part. They have
Page 4.
Yes. Page 46 running with
Internal page 4. Which paragraph?
middle
paragraph
portion.
number
Paragraph 5 start.
The co-partners have not given, has not
Hello.
issued NOC.
I have said that co-partners are acceptable because it's several years. But never come. Legally, they are come. That is why I have made clear for the people. 90
What
plus
do you say?
co-partners.
So how do you resolve this kind of a problem? If what he's contending is correct, that one has gone missing and the legal heirs are not found. The N.K. Kalita, Learned Counsel for the petitioner. Petitioners has submitted that so far as the co-partners are concerned, one of the co-partners is missing and the legal heirs are also not traceable. Full stop. He submits that under such circumstances, there should not be any impediment for releasing of 50% of the compensation amount. Tara? Sri J. Hendrick Learned State Council prays for some time to obtain instructions in this regard. Tara? We will give a date, list on 21st of July. Yes. Yes.
You can see. At 9.
58, they have not appeared. Okay. Heard three in item number 89 is what? Item number 58. Heard 3 R. Mazumdar Learned Standing Council, Education Department. This is what education? Elementary. The Standing Council, School Education Department, who by referring to the order dated 1/5/2025 has submitted that till date the respondents have not appeared. Para? In view of the above, list this case for consideration when? On immediately after the vacation. Yes, the next one. Heard Sri Armadumda Learned Standing Council, School Education Department, who submits that in view of the office notes, some time may be granted to him to take steps. Let such steps be taken within a period of a week, within a period of 3 days, 3 working days. Then Standing Council, School Education Department granted to enable him to obtain the instructions. Full stop. He submits that despite the office notes, steps that steps were indeed taken, and in this regard, he would like to place the details on the next date. List after the vacation. Get those memos listed before the court. Memos are there or not? No, Heard Sri Armadumda Learned Standing Council, School Education Department. Full stop. Though office notes reflect that steps for service of notice have not been taken, Sri Mazumdar the Learned Council has submitted that steps were indeed taken, and in this connection, he has also placed before this court the status report. Full stop. He has submitted that perhaps the steps have been, the copies have been misplaced somewhere in the process. Let the matter be verified by the registry and the matter be listed and the case be listed immediately after the vacation. You put this on record. The status report, and a copy is kept with the records so as to enable the registry to verify. And a copy of DDB.